foreclosure law?
Yes, I asked you if you were familiar with non-judicial foreclosure law.
It's been a while.
Okay. Well, you did write a memorandum about it and issue an informal legal opinion on the matter, correct?
If you're referring to the August 1st letter, I did assist Mr. Vassar in putting that together.
Okay. And in doing so, you probably had to research the law on non-judicial foreclosure opinions, true?
Not necessarily.
Okay. You're aware of when non-judicial foreclosures take place, correct?
Based on the document that I prepared, I believe it was the first Monday or Tuesday of every month, but
Okay.
That's my recollection.
Okay. If we said it was Tuesday, would you agree with that?
I would have no reason to disagree.
Okay. Now, the fact that that occurs every single Tuesday, that singular Tuesday of every month, that's a reason that Ken Paxton could have said, Mr. Banger, we need to get these done this weekend. True?
Yes, that could have been a reason.
Okay. And to be fair, Nate Paul is not the only person that had properties that were subject to potential foreclosures on that date, was he?
I don't know for a fact, but it seems reasonable to assume there would be other properties that would have been subject to foreclosure.
Okay. Potential homeowners, correct?
Again, I don't know of any particulars, but it's entirely possible.
So it's safe to say that it could have been someone that didn't have a job and didn't have money to pay their home loan, correct?
I have no reason to agree or disagree with that. I don't know.
Okay. After that informal guidance was issued, and to be clear, Eric, would you mind pulling up House Boards 119? That was not issued like a legal opinion was normally issued, correct?
Are you referring to?
No, I'm asking you personally.
Which
that was
document?
not issued like a formal legal opinion, correct?
It did not go through the formal process.
It was really
To the witness, excuse me, if you can just answer yes or no when you can. Okay.
It was just a news post, right?
Which document are you referring to?
I'm referring to the informal guidance regarding the non-judicial foreclosure sales that you signed instead of Ryan Vassar.
No.
It was a post on the website, right?
I believe it was made available to the public via our website.
Okay. And if we look at House Board 119, you state, we compromised by urging that, we agreed to compromise by placing a short, noteworthy post on the website, correct?
Yes, I wrote those words.
Okay. Now, after that noteworthy post, we're in August of 2020, true?
We are in August of 2020, and I do think I need to correct the record on something
Just
that
a
you
yes
asked
or no
me.
question. Was it August of 2020?
We are in August.
Okay. You had no knowledge about anything to do with the renovations with regard to Ken Paxton's house at that time, did you?
The knowledge I had would have been through conversations with Mr. Mateer via Mr. Wicker.
You have no personal knowledge of that, do you?
I did not discuss that with Mr. Paxton, nor was I at his house.
You do not know who paid for the renovations to the Paxton's house?
At that time, I was unaware of who was paying for the renovations.
You don't know. You haven't seen any documents, have you?
I have seen documents that include testimony from individuals who have described.
It's a yes or no question.
I have seen
Have you seen documents that specifically show and prove who paid for those? Have you seen receipts?
I have seen documents strongly suggestive of who paid for that.
Okay. When did you first send your application for the Alliance Defending Freedom?
It would have been sometime in October.
Okay. Was it prior to leaving the Attorney General's office?
Yes, I was in conversation with ADF prior to leaving the Attorney General's office.
So when you said earlier that what you did with regard to reporting Ken to the FBI, going to the FBI being a death warrant for you, It did not affect your ability to get another job, did it?
It ended my ability to be employed by the Attorney General's office.
Well, no, because you resigned. You didn't get terminated, true?
I was constructively terminated.
Okay. You submitted a letter of resignation, did you not?
I did.
And then you went to work for a company or a firm that you had already applied for, true?
I did.
In the end of the day, you would have to agree that Mr. Paxton makes the final call on what opinions are issued by the Office of Attorney General, true?
I wouldn't put it quite that way.
Well, he has to sign the document, doesn't he?
Mr. Paxton has authority to make the final signature on the document.
So, in the context of a senator perhaps, if there's a piece of legislation that they don't like, or let me rephrase that, if there's a piece of legislation that one of their staff members does not like, and they want it to go through, the senator overrules his staff member, true?
I do not know how the senators make their decisions. I can only assume that senators, much like statewide elected officials, have ultimate authority in their offices.
Have you had any conversations with any statewide officials or legislatures regarding this case?
Nothing specific.
Nothing specific. Is there any record of that, of what you actually said?
No.
So it's kind of like your conversations with Mr. Hardin and the House Board of Managers?
No.
May I approach you, Your Honor? At this time, Judge, I would offer Attorney General's Exhibit 1004.
No objection. It will be admitted into evidence.
May I approach the witness, Judge?
Yes, you may.
Mr. Bangert, I've highlighted in orange on this document. I'm going to hand it to you. I'm going to ask you to read it, okay? The highlighted portion, okay? I want you to read it aloud, Mr. Bangert.
The highlighted portion.
One moment. Does Eric have it?
Eric does not have it, Judge. This is more of a rebuttal exhibit, if you will. So, Mr. Bangert, if you could read it aloud so that our jurors could hear. The highlighted portion.
Yeah, read it.
Pardon me, Your Honor. May I approach him and ask him to highlight the portion that he's highlighted for the witness so I'll know what he's talking about? I just want to highlight on my copy. Thank you. Thank you.
I'm going to ask you to read the highlighted portion now. Aloud, Mr. Bangert.
The highlighted portion states, accordingly, my administration, to the extent reasonably necessary to prevent the further spread of COVID-19, will take all lawful measures to prevent residential evictions and foreclosures resulting from financial hardship caused by COVID-19.
That is an executive order issued by the Trump administration, Mr. Bangert. Were you aware of this executive order when you filed or sent Mr. Vassar that email on September 30th of 2020?
Look at the date of the order. It's August 8th. I don't recall if I was aware of this order, but it was irrelevant.
It was irrelevant.
Yes.
Okay. It was a week after you just issued an opinion with regard to foreclosure sales, was it not?
It was 1 week after the August 1st opinion.
Okay. But it's your opinion that it's not relevant to your summary of what happened on that foreclosure opinion you drafted?
Completely irrelevant.
Okay. I'll take that back from you. May I have a brief moment, Judge?
Point of inquiry, please, Your Honor. I'm looking at the record as it was. Maybe counsel wants to have an opportunity to correct it. I think he referred to the order in a question. That is an executive order issued by the Trump administration, Mr. Bangert. I suspect he meant to say the Abbott administration, but I just want to make sure the record is correct. I don't know which he meant.
No, it's a federal order. I meant the Trump administration.
Pardon me?
It's a federal order. I meant the Trump administration.
Thank you. Okay.
I want to talk to you more about your representation by Johnny Sutton, Mr. Bangert. Was it after you ended your employment at the Office of Attorney General that you hired Mr. Sutton?
I began working with him prior.
You began working for him prior?
I began working with Mr. Sutton prior to ending my employment, yes.
You searched for Mr. Sutton on September 22nd of 2020, did you not?
He was recommended to me.
Okay.
I can't recall searching for him on September 22nd.
Okay.
Thank you.
This time, Your Honor, I would offer Attorney General Exhibit 312.
Any objection?
No objection?
It is admitted into evidence.
Okay. Mr. Bangert, this is a download of your computer, and I'm going to approach you with it. I'm going to have you look at it and refresh your recollection. I didn't realize Eric had. Eric, you got it published, don't you? Okay, thank you. We see here on September 22nd of 2020 that you actually searched Johnny Sutton's law firm.
That's what the document represents, that I searched for the ashcroftlawfirm.com.
And that is where Johnny Sutton is employed, true?
He's one of the named partners there.
Okay. That is 8 days before you decide that you're going to go to the FBI and report Ken Paxton.
We went to the FBI 8 days later. Yes, that's correct.
So you were searching for an attorney before you even knew that Brandon Kamek was issuing subpoenas at those banks.
Oh, no, I don't believe this had anything to do with looking for Mr. Sutton to retain him.
Oh, it's just a coincidence? Yes or no?
It probably is, yes. There's no reason. We were not searching for a counsel prior to that. I was not.
I'm going to ask you a question that Mr. Busby has stated earlier. Have you ever heard the term, there's no coincidences in the city of Austin?
I've never heard that term before. And there are plenty of coincidences.
It was a yes or no question, Mr. Bangert. You said you'd never heard of it.
Never heard of it.
So September 30th, you guys go to the FBI, true?
We did.
All right. Now, that is before you become aware of a second referral made to the Travis County District Attorney's Office, true?
Trying to recall when we became aware of that second referral. It may have been, I just don't recall precisely the order of events, but I believe it was.
I mean, you seem to have a great recollection of the order of events when Mr. Harden had you on direct examination. Are you saying that you're forgetting now?
No, I'm telling you that I'm trying to recall specifically when I learned that fact, but I did learn that there was a second referral.
Okay. And it was after you went to the FBI?
That is entirely possible, yes.
Okay. And then the next day, that is when you guys decide to reach out to Ken Paxton, after you've already outed him to the feds, right?
We reached out to him the next day.
Okay, that's what I said. So that's a yes, right?
We did reach out to him the next day.
You were pretty
The
active.
witness, but once again, witness, when you can answer yes or no, if you can, answer yes or no.
I cannot answer yes or no to that question. I'm answering what I can.
Okay. You were pretty active on October 1st.
I was active on October 1st, yes.
Okay. You guys, when I say you guys, I mean the executive level administration. You had a group chat going, did you not?
We did,
And you participated in that group chat, right?
yes.
We heard you talking to Mr. Harden about some of the text messages in that group chat, right?
Yes,
And specifically, they were talking about a draft that was circulating between you and the other executive level attorney generals, right?
yes.
Eric, would you mind pulling up House Board 225? And in that message, well, it's safe to say that the first draft that you all created did not go to the FBI, right?
I don't know. This letter that's
Right.
being referred to here?
It
No.
was revised and edited to an extent.
The document, I don't recall if it ever went to the FBI. We were working on an internal document
Okay.
to memorialize our complaints.
Right. And the first version of that complaint, well, from what we look at in House 225, Jeff Mestier says, from Maxwell, read the letter, not sufficient. A request letter must allege specific allegations that are in violation of state law to include documentation of criminal act. The only thing you have is what happened today, and that is documented. Is that true?
You added the word "and."
Okay.
Apart from that, you read it
Excuse me?
correctly.
But that's what the text says, right?
That is what the text says.
And
with that addition.
presumably that's regarding the initial draft that you guys created to memorialize your complaint to the FBI, right?
I don't recall specifically that that's what this was.
Are you forgetting all of a sudden? Because you had a crystal clear recollection when Mr. Harden had you on direct examination, Mr. Bangert. Do you not remember this? You're here to testify in the court of impeachment. Do you not remember the day that you went behind Ken Paxton back to the FBI? Do you not remember that?
Sir, we did not go behind the Attorney General's back.
Did you tell him you were going to the FBI? Yes or no?
Sir, we did
Yes
not
or
go
no?
behind
Did you-
the...
Mr. Bangert, I'm asking you yes or no questions. Did you tell Ken Paxton you were going to the FBI? Yes or no?
I cannot answer that question with a yes or no.
Witness, you'll answer the question.
Yes or no, Mr. Bangert?
Provided him with ample opportunity.
That's not what I asked you. Did you tell Ken Paxton you were going to the FBI? Yes or no?
We gave him ample opportunity.
That's not what I asked. Objection non-responsive, Your Honor. I'd ask that he answer the question before him.
Witness is ordered to answer the question, yes or no.
Mr. Bangert, it's a very simple question. Did you tell Ken Paxton that you were going to go to the FBI?
On September 30th,
It's
we
a
did
yes or
not.
no question, Mr. Bangert.
It
It's
is
a
not
yes or no.
a yes or no
It is a yes or no question.
counsel.
Excuse me, sir. Your Honor, he answered the question, but because he was talking on top of him, he didn't hear it. He said on September the 30th, we did not. And he starts interrupting him halfway before, and the court reporter probably had trouble hearing, we did not. So I just asked him to let him finish what he's saying and not talk on top of him, if for no other person than the court reporter.
You can ask the question one more time.
Mr. Bangert, it is a yes or no question, and I want a yes or no answer. Did you tell Ken Paxton that you were going to the FBI?
I did not tell Ken Paxton before I went to the FBI.
Okay. We're not done with that. Your next message after we're talking about the first draft of y'all's complaint says, okay, sounds like we need to beef up the specific allegations. Does it not?
Yes, that's what I wrote.
So you actually had to go back in there and put more words and more filler into that complaint, didn't you?
No.
No? Well, the first complaint clearly wasn't sufficient if we're to go off your text messages, right?
You said the word filler. That's an inaccurate characterization
You had to
of what
amend
we
it.
were doing.
Well, let's look down there. Eric, if you could hop off of the zoom in. It says, sound like we need to beef up the specific allegations. You needed to beef them up, right? You needed to make them sound stronger. True or no?
We needed to include additional allegations to substantiate what had happened.
And so it's after that that you started talking about other things that Ken Paxton had done previously that you didn't think to include in the first version of the complaint, right?
I wouldn't put it that way.
You wouldn't put it that way. And to be clear, this is all coming to fruition because Brandon Kamick is serving subpoenas on a bank. True?
That was in part, but not entirely.
And all the while, you didn't even know that the Travis County District Attorney's Office sent a complaint directly to Mr. Kamick that did not go to the Office of Attorney General.
That would have been much more concerning if I'd known that.
So you didn't know that?
No.
Eric, would you mind pulling up Article 6? Or excuse me. Article 5. The allegation in Article 5 is that Paxton misused his official powers by violating the laws governing the appointment of prosecuting attorney pro tem. You would agree with that, right? That that's the allegation?
Yes, that is the allegation.
Mr. Bangert, Mr. Paxton, excuse me, Brandon Kamick was not an attorney pro tem. True or not true?
It's difficult to
It's
classify
true.
what he was.
True or not true?
I don't personally believe he was properly ever appointed a prosecutor pro tem.
And the Travis County District Attorney's Office never recused themselves officially and formally from the complaints made by Nate Paul to their office. True or not true?
I'm not aware of any recusal.
Okay. May I approach you, Your Honor?
Yes.
I want to go back to your last answer, and I'm going to re-ask you this. Brandon Kamick wasn't just not improperly appointed as an attorney pro tem. Brandon Kamick was not appointed as an attorney pro tem at all.
Not to my knowledge.
At this time, Judge, I would offer AG Exhibit 95.
I think that's on our list of already admitted.
It is. No objection.
Okay.
It's already admitted.
Thank you, Judge. Eric, would you mind pulling up the first page to AG 95? Mr. Banger, we talked about you being heavily active on October 1st of 2020, and you agreed, right?
I was.
And one of the many actions you took that day was that you took it upon yourself to email Jeff Mateer's letter to Brandon Kamick terminating his employment, did you not?
I did not take it upon myself. I agreed with Mr. Mateer that this would be an appropriate way to handle this.
Okay, so you and Mr. Mateer were both of agreement to do that.
We were in agreement to do this.
All right, I want you to flip to the second page of that correspondence. You would agree that, and Eric, if you would do the same, you would agree that that is the letter that Jeff Mateer provided to terminate Brandon Kamick's employment, right? It's produced by the House, Mr. Bangert.
Correct. I want to make sure that the word terminate is accurate here. We were told him to cease and desist.
Third line, notice of termination effective immediately.
Yes, we do say that.
Okay.
Yes.
And just to be clear, you don't know all the work that Brandon Kamick put into that investigation, do you?
At that time, I was not aware of what he was up to.
And you were willing to just fire him without even thinking to pay him or compensate him for his time and his services as a lawyer?
We terminated him in this letter and told him to cease and desist.
Without even thinking about giving the guy a little bit of money for the time and effort he spent on this investigation? Yes or no?
I would not put it that way.
Okay. You didn't pay him, did you?
No, we did not.
All right. But the thing I really want to focus on, Mr. Banger, because you're a man that has attention to detail, right?
I do my best.
I want you to look right under that Attorney General seal at the top of that exhibit, okay? Do you recognize anything that should be there?
It's been several years since I worked with letterhead. It has the seal of the Attorney General's office there.
How about your boss's name? You see that there?
His name is not here, no.
Yeah. You went ahead and sent it without his name, didn't you?
I'm trying to recall. I think there was a version.
You're looking
of
at the
letterhead
document, Mr. Banger.
Excuse me, he's trying to answer the question. Can you please let him before he jumps?
Overruled.
You're looking at the document. Is Ken Paxton's name on that document you sent to Brandon Kamick or not?
His name is not on the letterhead, no. But just for the record, I do want to point out his name does appear in the
Objection,
letter.
Judge, say non-responsive. I didn't ask this witness a question.
Sustained.
And I'll pass, Mr. Banger.
Mr. Bangert, I want to start to try to ask you a few questions again to go back to this opinion that sometimes has been referred to as the midnight opinion. Originally, if I can, I would like to bring up, please, Stacy, Exhibit 112. Now, can you look at this and determine and help me out and tell me whether or not this is the original draft that y'all did on and presented to the Attorney General on that Saturday afternoon? You need a moment to look at it, or would it help you to have a hard copy?
A hard copy would be helpful, yes, sir.
Can we? And Stacy, do we perhaps have a hard copy for the court?
But I can tell you without looking at it that this is not the original version that we sent.
Now, let me follow up on what your observation is. In what order would this draft have been?
I'm assuming this is the final draft. It would have been the very last thing that was produced.
Would you look at the first page, please? And the last page, if that helps you.
No, this is not the final draft. I can now see there's no signature on it.
Right. Would you look at the opening paragraph and see what that seems to be saying in terms of the original position you took?
Yes, this refreshes my recollection.
Pardon me?
Yes, this does refresh my recollection
All
as
right.
to that.
And now that you look at the language in the first paragraph of Exhibit 112, what does that tell you in terms of which draft or order it was?
This was one of the early...
Now, let me tell you a problem for you to keep in mind. When you look to the left for the iPad, there you go. Perfect. There you go.
There we go.
All right.
Yes, this was one of the early drafts.
And in the first paragraph, would you look at the sentence that begins with "we conclude"? Would you highlight for me, Stacy? Read this paragraph out loud to the jury, please.
Yes. We conclude that a foreclosure sale of residential or commercial real property constitutes a service to which no occupancy limit applies under Executive Order GA 28, and local governmental bodies therefore lack authority to restrict in-person attendance at these sales.
All right. Now, at that time, what was the legal basis for you concluding that there wasn't a restriction and that it could be conducted?
It was GA 28, the governor's order.
All right. And what was it about GA 28, the governor's order? And I may have a copy there. I couldn't locate it on my desk. If somebody finds it, they can bring it up to me. But what was it about the governor's order, and when was that order, that you concluded would allow essentially the foreclosure sales to go forward, particularly outside? Thanks. Thank you very much.
Yes, there were a number of exceptions in the governor's order to in-person gathering restrictions.
With the court's permission, I'm going to mark this as an exhibit number 621. Thank you so much. 631 or 633? 631. Thank you. I'm going to tender it to counsel, Your Honor, because I don't have an extra copy right now.
No objection, Judge.
631 shall be admitted into evidence.
Thank you, Your Honor. Do we have a copy by chance for the court to have up there? This
Always
only-
nice for the court to have a copy.
This only came up during the lunch hour. I apologize.
Thank you, sir.
And one for him. Thank you very much. Now, I don't know whether or not, and I'm going to ask as we go along, whether Ms. Manella can figure out a way to balance these. First of all, if there's a way to do a split screen here, Stacy, 112 and 115, and I believe I will represent that 115 is the final order. and I believe 115 is in evidence. Now, if you could look at these two orders, is the one on the left, the draft we talked about, Exhibit 112, what your first finding was?
Yes, our first finding is summarized in the first paragraph. We conclude that a foreclosure sale. Yeah, there we go. Thank you. We conclude that a foreclosure sale of residential or commercial real property constitutes a service to which no occupancy limit applies under Executive Order GA-28, and local governmental bodies therefore lack authority to restrict in-person attendance at these sales.
All right. Now, I'm going to ask you if you could leave that up, please, Stacy, first. And then I want you, if you would, I want you to look over to the government's executive order on page 3.
Okay. And I don't have a copy of the order.
Do we have one more, Mark? No.
Thank you, sir.
Thank you. And I believe that 112 was just never discussed as one of those that you did not object to. I want to tend it to you again to look at. I just looked to make sure. I'm told that 112 is not in evidence, and I apologize. The headlining is not. This is the original draft they proposed to him.
No objection, Judge.
No objection, 112 will be submitted to evidence.
And I apologize for having published that before I realized it. That's my fault, not anybody else's. Now, I want to ask you, you referred in your testimony just a moment ago that in your first draft, in which you basically had a ruling that said these foreclosures, particularly outside, would be allowed. And then you said that was partly based on the governor's executive order that he had previously issued. And you talked about it as General Order 28, correct?
Yes, no occupancy limit applies.
I'm sorry?
Yes, no occupancy limit applies under
All right.
GA-28.
And what role can you point us in the governor's General Order 28 to the section that you relied on in that initial opinion that said they could be open to the public? They could, foreclosure proceedings could be open.
Yes. May I see the second page of
Pardon me?
Exhibit? May I see the second page of Exhibit 112?
All right. We move to second page. Thank you, Stacy.
Yes. Yes, we reference it here. We address your question.
No, I'm sorry, Stacy. What I want to do now is go to, if you have ordered, I don't know if you have 631 loaded, do you? If you do have 631 loaded, could you go to the second page of that? And you can sacrifice the one on the right. You can take down 115 and put in the governor's general order. And by the way, the executive order, before you move, Stacy, that is dated. Can you see on there what date it is? Is it June? Can you see June 20th?
I can. It's June 26th, 2020.
All right. Now, so that executive order, did it not, existed at the time that you were drafting your opinions at the request of the Attorney General?
They did.
All right. Now, what is it on page 2 of the governor's executive order that led y'all to conclude and say in your first draft that foreclosure sales could be conducted?
Yes, if you will go to page 2 of Exhibit 112.
All right. Stacy, if you go to page 2 of the
first
general
full
order.
paragraph.
Pardon me?
The first full paragraph. We point out that Executive Order 28 has a baseline limitation that does not apply to...
I don't, I'm confused here, and it's probably my fault. Stacy, may I approach, please? As usual, Ms. Manello is more on top of it than I. You directed me, and it's my fault, you directed me to page 2 of
Exhibit 112,
112, your initial draft opinion.
the initial opinion.
And I was trying to go over to the governor's order. But let's
yes.
stay with 112 first.
Okay.
So now, Stacy, let's put up 112 and the governor's order. Those are going to be the two on the screens. Go ahead. All right. Tell me what it is about 112 that you think is relevant to what we're saying.
Yes. This paragraph that is highlighted,
All
the
right,
second
move it away
paragraph.
from that microphone. You got to move it to
Yes.
you. There you go.
The paragraph calls out the executive order's baseline limitations on gatherings. It then says this limitation does not apply to any services listed by the U.S. Department of Homeland Security's Cybersecurity and Infrastructure Workforce version 3.1 or subsequent version. CISA guidance is how we referred to that. Among the services listed in version 3.1 of CISA are residential and commercial real estate services, including settlement services.
And then if we go down to,
Yeah.
you go down to about a sentence or two down there, you say, do you not? And there is no better indication of that intent than the words that are chosen, correct?
That is correct.
All right, now let's stop there and let's go over to the second page of the general. And by the way, could you just explain to us lay people what CISA is, CISA? What does that stand for?
It's the Cybersecurity Infrastructure Workforce. CISA is I'm trying to recall exactly what that acronym stood for, but there was a guidance document issued by an agency within the federal government that called out essential services and infrastructure that should be exempt from COVID limitations.
Okay, so for us lay people, essentially, are you saying that you are going from your draft that you did to show why the governor's proclamation or executive order would have exempted it as far as you were concerned when you dropped the original draft? Is that right?
That's exactly right. We were trying to demonstrate, and we did demonstrate here, that a straight application of the governor's executive order excluded these types of foreclosure sales from limitations.
All right, stay with me. I don't want to tell everybody how to build a Swiss village when we're trying to just do what time it is. But if we go to page 2 of the governor's order, where in there does it point people to the legal basis you made for your original order?
Paragraph 1A.
Stacy, can you, yeah, on the left? Can you do 1A? Thank you. Can you highlight 1A for me? There you go. Mr. Donnelly wants to make sure that I let you know that we can't give you a copy of the CISA document because it's a government confidential document, okay? But having said that, would you explain in this highlighted language how this tells you...
Objection to that sidebar about the CISA document. I don't believe it's confidential.
Sustained.
Can you explain in the highlighted portion here?
Say again?
Yes. Explain in a highlighted portion how that impacted your original opinion you recommended in a draft to the Attorney General.
Yes. This was part of the exemptions from occupancy limits, and the CISA guidance called out a number of essential services, infrastructure, among which, as we point out in our original draft guidance, are residential and commercial real estate services, including settlement services.
So explain to the court what that meant as far as the conclusion that you ultimately reached and recommended to the Attorney General.
Based on a plain text interpretation of the governor's order, foreclosure sales would not be subject to occupancy limitations.
If it affected any real estate?
Yes, and that was a straightforward textual interpretation.
So in your original one, did you actually base it upon an exception the governor's executive order had given to say that it should be open to the public?
Yes, it was a straightforward application of the governor's executive order.
Now, how did you get around that then when you were ordered to come up with a different answer? And if we can, Stacy, let's now put take down the governor's executive order and put up Exhibit 115, please. Now, tell us what it is about what did you do that, since you had based it on a specific reading of the governor's statute, and now you're being asked to give an opposite view? How did you do that?
Could you go to page 2 of Exhibit 115?
Yes. Where do you want to be?
If you'll look at the third paragraph. We simply jump straight to the general occupancy limits.
Pardon me?
We jump right to the general occupancy limits, excluding conversation about CISA.
Direct us and Ms. Manella where to highlight that you're talking about.
The language, this general limitation, however, is subject to several exceptions.
Where you read?
One such exception is found in paragraph 5 of the order, which limits outdoor gatherings to 10 persons or fewer without approval by the mayor or the unincorporated territory. So we switched out the applicable exceptions in the order to eliminate any reference to the CISA guidance.
So what you did is you just wrote out a paragraph, did you not, of the governor's order?
We determined, based on the Attorney General's instructions to us, that we would no longer apply the exception that had been granted by the governor's order.
When you say based on his instruction, did he actually talk about that language?
No, he told us to reach a different conclusion, and that was the only way to do it.
I don't need it, but thank you. All right. Now, finally, I want to make sure, I don't know that I need to introduce this, but had you read, may I approach the witness very briefly?
Yes.
I'm going to approach you and show you what we have just marked as a new exhibit. House Board of Managers Exhibit 632 is a new listing. I'll tender to the court and the council with the admonition that I don't intend to read all this. So my question to you, though, without having introduced it yet, I will actually make it for ease, move to introduce it. We move to introduce House Board of Managers Exhibit 632.
Judge, I would object to this witness testifying to this document, and additionally, this document has not been produced. There's no bait stamps on this document.
No, that's certainly right. It has not been produced. We never foresaw this issue. So we've just gathered this during the lunch hour and printed it out here, and we've tendered it to him. Whatever his position is fine, but he's certainly right. It's never been produced. We did not foresee this issue.
It's a 40-page document riddled with hearsay, Judge.
It's a government record, I think. Probably stands on its own. It's a public government record.
Mr. Rosso, do you need time to review this 40-page document?
Judge, if I could have 1 or 2 minutes.
If I may, I think that's a reasonable question. So if I could speed it along, what I'll do is I'll withdraw, wait on the motion to admit it, see if I can elicit testimony that gets the same, it may not become an issue ultimately. But if I do want to, I'll give him notice so he gets time to read it.
Hold on 1 second.
Judge, we're ready to go.
All right. Thank you. Now,
Do you withdraw the objection then?
No, Judge. Judge, may we have 5 minutes to just look through this document real quick?
Yes.
fine.
We'll stand at ease for 5 minutes. For 5 minutes.
That's my last copy. No, let me put it down. I put it down here. That's all right, I'll find it. Way back, 16. Where's the page number?
Yes, sir. Here shortly. Here you go. This one.
Okay,
That's what they were.
what does that say?
Residential.
I know, what does that say, and where's it come? Just as an essential function? Yeah.
Mr. Osso, you,
Your Honor, I have no objection to this exhibit. Just for clarification, it was House Exhibit, what's the number, Rusty? No objection to House Exhibit 652. Excuse me, 632.
no objection to 632. Do you want to admit it into evidence?
Yes, please.
Okay.
All right.
House Exhibit 632 is admitted.
I want, if I can, I'm going to walk up to you and I'm going to show you a page. I have, by the way, I mistakenly called this a confidential document. I've looked at it. It is not. It is a public document. There's nothing confidential about it. That's one of 230 mistakes I'll make during this trial.
Objection?
Okay? So now, thank you.
Object to that sidebar.
Excuse me, what is the
Move to
objection?
strike. Sidebar, and I just moved to strike Mr. Harden's comments.
Sustained.
Thank you.
You know better than that. There you go.
That makes it 237. Thank you. I'm going to walk up. I'm going to show you where the tab. I'll show counsel where I'm pointing it to. I'll go by him, show him what I'm about to address you to, because I can't send you to a page number. Just a second. Now, on Exhibit 632, is there a provision of it, and I showed you a tab, so there's no secret about this. Is there a provision in this document that you relied on in coming to your conclusions that you presented in your first draft to the Attorney General?
Yes.
And shown in Exhibit? Can you explain? And I don't know that, Stacey, you don't have this loaded, do you? Do you really? All right. Let me show you where I'm going, Stacey, because again, I don't have a page number. May I approach her? Now, if you would, on the screen that she's already anticipated, is there somewhere on this screen that you can direct the viewers to that has any language that you used as a basis for your original opinion that you delivered to the Attorney General on that Saturday afternoon?
Yes, the very last bullet point. Residential and commercial real estate services, including settlement services.
And what did that mean to you?
We interpret that in the original opinion.
And then can you read the portion of Exhibit 112? Stacey, can you split it for me? 112, in your opinion, that was really based on this segment, this one little excerpt out of 632.
Yes. Second paragraph, second page. A court's main objective in construing the law is to give effect to the intent of its provisions. And then we footnote, and there is no better indication of that intent than the words that are chosen. Then we footnote, where text is clear, text is determinative of that intent.
Microphone. All right. Keep going.
One dictionary defines a service as work that is done for others as an occupation or business. Real estate is defined as land and the buildings and permanent fixtures attached to it. Thus, real estate services include services performed for others as an occupation or business that pertain to land or the buildings and permanent fixtures attached to the land, insofar as the performance of auction or foreclosure sale services related to commercial or residential real property. Such services are one specific iteration of residential and commercial real estate services.
All right. So, to reduce it down to its basics, in recommending or in your drafting to the Attorney General, saying that there should be no restriction on the foreclosure sales, did you rely on a government document as guidance as to why it would be considered an essential service or activity that was exempted based on the governor's executive order?
Yes, the specific government document referenced and incorporated into the governor's order.
All right. So in effect, in y'all's opinion at that time, was your recommendation that it would be open and they could have foreclosures based on a combination of the governor's order, and if you go to the basic item that they're referring to in the governor's order, that would have said essential services that would have included foreclosure sales for either commercial or real estate property?
Yes.
Residential property, excuse me.
Yes, we conclude that it is not, there's no occupancy limit applicable pursuant to Executive Order GA-28.
Now, when you then were directed to come to the opposite conclusion in the drafting, that is the final product in the exhibit that we've been using, I think is 115, you had a challenge to write around the basis for your first opinion. So what did you do?
Objection to leading and assuming the answer in the question.
Sustain, rephrase.
What did you do to come up with the opposite conclusion you had originally arrived at?
A couple of things. If you go to page 2 of Exhibit 115, we first point to the general occupancy limitations in the third paragraph. Next, we do point ultimately to CISA at the bottom paragraph. And if you would go to the next page, at the very bottom of the first full paragraph, and this is really the kicker, the court's main objective in construing the law is to give effect to the intent of its provisions.
Slow down, please. On behalf of court reporter.
Yes, my apologies.
And the volume on behalf of the people on the floor. Could you speak a little louder, please?
Yes. We repeat our commitment to textualism, which was a guiding star of our office at all times. We then point out that based on our analysis of the words, we believe that outdoor foreclosure sales, last sentence, are not exempted from the 10-person attendance limitation.
And
we completely reversed it.
Excuse me, I'm sorry. What was the only thing that had changed since you had the original opinion?
The direction from the Attorney General.
All right. Now, you had questions about whether or not it would have happened anyway because of other subsequent events. At the time that you drafted these two opinions, did you have any idea that Nate Paul had bankruptcy hearings scheduled?
Objection to asked and answered. And this witness said he didn't have specific knowledge, so speculation.
Sustained.
In this particular matter, did you yourself know about any bankruptcy hearings that were set any foreclosure hearings that were set in the foreseeable future? Just you yourself, were you aware?
Objection to asked and answered.
Not by me.
And lack specific knowledge.
Overruled. I sustained your first objection, which forced him to ask the question a second time.
Thank you, Your Honor. Did
No.
you yourself?
I had no specific knowledge of any specific foreclosure sales.
All right. You were there when he introduced a certain document. And if I can I have Exhibit AG Exhibit 295, please, Stacey? You have heard earlier questions on direct as to whether or not, have you not, sir, these opinions would be of help to somebody who was somebody that was opposing a foreclosure hearing, right?
I recall those.
All right. Now, if you could, can you identify, had you seen before we showed you this Attorney General exhibit, had you seen it before, this exhibit that he's entered into evidence?
No, this is the first time I've seen this document.
All right.
With the cross-examination.
All right. Now, I want you, I'm going to read this to you and ask you what the import of this when you look at the exhibit is. Judge Gamble, August 3rd, 2020. As it is relevant to these proceedings, please see the attached guidance just released by the Attorney General's office. Had been just released, hadn't it? What date was it released?
The 1st.
1st of August. That was a Sunday, was it right?
I believe midnight the 1st. I think that's right, yes.
So this is just Tuesday after you released the opinion on, or after you provided the Attorney General the opinion on Sunday the 1st, correct?
It's 2 days later, yes.
Keep your voice up away from the microphone. You're
2 days
too thin.
later, yes.
All right. Regarding the foreclosures may not proceed unless specifically authorized by the mayor and the city of the foreclosure, given the standing 10-person restriction would violate Texas Property Code Chapter 51. Does the attachment include the opinion that we have just been so laboriously going over?
Yes.
Would you look to the last page of that opinion and see if that's the final one that we identified as Exhibit 115
It is.
with your signature?
It is.
Does the cover page identify on behalf of whom
It
this
does.
particular email, this particular pleading was filed in a court here in Travis County?
Yes.
And who was the person that represented whom
This is one of the...
was presenting this particular pleading and urging that your opinion was relevant to their case?
This is one of Nate Paul's companies.
Do you even yourself personally know how the judge ruled one way or the other on this motion?
Not in this case, no.
All right. And in fact, are you familiar with any other cases? Nate Paul cited this opinion and seeking to foreclosures in that year of 2020 after you rendered your final opinion?
Only through news reports that came out after.
All right. Was it multiple places?
Yes.
Objection to hearsay, Judge.
Through.
Do you withdraw that question?
I think actually he meant to say leading. It was leading, it wasn't hearsay.
No, I meant to say hearsay, but I'll retract the objection for Mr. Harden.
That's all I have.
Recross?
Yes, Judge.
Mr. Rosso?
You just cited the Cybersecurity and Infrastructure Security Act pretty precisely to Mr. Harden on direct examination, did you not?
I had it in front of me.
Okay. You also cited the day of the week that you issued that opinion, did you not?
The day of the week was August 1st when we issued the opinion.
I'm just surprised because you showed an uncanny ability to remember things when Mr. Harden was asking you questions, as opposed to when I asked you about the same documents during my cross-examination. Can you explain that?
I disagree with your characterization.
Okay. We'll agree to disagree. I don't have an e-copy of this CISA document that the House has just produced, but I think Mr. Harden had you reference page 16 of that document, did he not?
He did.
He had you reference the very bottom part that I have highlighted in orange, and I'm going to show the jury. And it says settlement services, correct?
One of the things it says is settlement services.
Now, behind the term settlement services in this document, there is no definition as to what settlement services are.
I do not see a definition.
I don't see the word foreclosure sale or non-judicial foreclosure sale behind it, do you?
The word foreclosure sale does not appear.
Do you have a real estate license?
No.
Okay. Would it surprise you to know that people that have real estate licenses oftentimes engage in settlement services to close on homes?
I would not know.
It deals with title work and things of that nature?
I would not know.
Okay. You won't find the word foreclosure sale in that definition, sir.
This definition? It is not in the word foreclosure does not appear there, but that's why you engage in legal analysis and construction.
Legal analysis and construction, which means that somebody else, another attorney, perhaps the Attorney General, could have a different viewpoint as to what a settlement service is, correct?
He could have any number of viewpoints about that.
That's why they call it the practice of law. Zone of reasonable disagreement. That happens a lot in law, does it not?
Not in this case.
Okay. Well, that's your opinion, but let's talk about facts. Are you aware of whether or not the opinion that you wrote that you said was unconscionable and opposite of Attorney General policy, did anybody challenge that in a court of law?
Did anyone challenge the opinion?
Yeah, the opinion in a court of law.
I'm not aware of it being challenged. I don't know how you would do that under standing doctrine.
Okay.
The witness may step down.
Judge, I have one more question if the court would entertain it.
Will the witness come back? One more question.
Prior to your term as a politician, did you or did you not practice real estate law? No. Paxton practiced real estate law, did he not?
I believe he had some real estate experience back in his past.
Okay. So when you guys are going back and forth regarding the definition of things, it's possible he had some background knowledge of what settlement services meant?
In this case, that was not the best interpretation.
Okay. That's your opinion, sir, correct?
No, that's the law.
That's your opinion.
I disagree.
You may now step down. House, call the next witness.
We call Mr. Ryan Vassar.
Yeah, please do.
Mr. Vassar, were you sworn in the other day in the group? Okay, I need to swear you in. Please raise your right hand. I do solemnly swear or affirm that the evidence I give upon this hearing by the Senate of Texas of impeachment charges against Warren Kenneth Paxton Jr. shall be the truth, the whole truth, nothing but the truth. So help you God. You may be seated.
Good afternoon.
Good afternoon.
Mr. Vassar, you and I have met at least once or twice, correct?
Yes, sir.
But I don't think we've talked about this subject. And that is, we have some microphone issues that you and I have to worry about. If you will try to make sure that you're speaking into that microphone to where everybody in the back of the room would hear, and I will try to make sure that I don't talk on top of you, and we go from there, okay?
Yes, sir.
Your full name?
Ryan Vassar.
That's going to work, if you can just stay with that. How old a man are you?
I'm 39.
And you married?
I'm married.
How many children?
4 kids.
How old? What ages?
Ages between 3 and 7.
Wow. In 2020, how old were they?
I had a 6-month-old, a 2-year-old, a 3-year-old, and a 4-year-old, I believe.
How are you employed now?
I'm general counsel for a local nonprofit organization in Austin.
When you left the Attorney General's office, and we'll get to that, how long were you unemployed before you found a place to land?
6 months.
What was your source of income?
Savings, but I was not employed as a lawyer for that 6-month period.
Did your wife work outside the home?
No, sir.
Let's go back now, a little bit of an autobiographical sketch review for about a minute and a half if we can. I'm not going to time you, but just roughly. Like where you grew up, your parents, what your background was?
I grew up in Big Spring, Texas, a small town in West Texas. I'm the oldest of 3 siblings. I attended Texas Tech University and majored in accounting. My father and grandfather are both certified public accountants. They both attended Texas Tech. They've had a CPA practice in Big Spring for the past 40 years, where they serve 3 generations of farmers and ranchers and salt of the earth people.
So how many years has your family been living in Big Spring?
My whole life.
All right. Now, when you finished as an accountant at Texas Tech, what did you do?
I moved to Dallas and worked in finance for about a year and decided I wanted to go to law school. And so I started working at Jones Day as a litigation assistant and during my application periods.
Does litigation assistant mean a runner?
Essentially, yes, sir. I was in charge of the documents.
And did you clerk or get to know anybody else of the legal profession while you were there? Other than the lawyers at Jones Day?
No, sir.
All right. Now, and then after you graduated, what year did you graduate from law school?
Law school was December of 2012. I'm sorry, December of 2011.
2011. And Mr. Vassar, were you involved in any outside, either political or social activities in addition to going to college and law school?
I was a member of the Federalist Society for Law and Public Policy Studies while in law school. And then I interned for 2 federal judges, one on the Southern District and one on the Fifth Circuit.
Which judges did you intern for?
Judge Lynn Hughes on the Southern District, and then Judge Jennifer Elrod on the Fifth Circuit.
Those were both college, law school internships, correct?
Yes, sir.
Were you involved in Republican politics at that time?
Not at the time, no, sir, other than just typical voting.
All right. And then after you finished law school, what did you do?
I served in Governor Perry's office of general counsel as an attorney fellow.
How long did you do that?
It was, I think, 6 weeks. It was a summer.
And then what?
And then I was invited to clerk for Justice Don Willett of the Texas Supreme Court.
So Justice Willett was on the Supreme Court. How long, to your knowledge?
How long had Justice Willett been on the court?
Yes.
He might have been appointed by Governor Perry at the time, maybe around 2010 or sooner.
I haven't sought to introduce it, but is it a fair statement that Justice Willett had a extremely complimentary letter for you to have you go off and seek employment elsewhere when your service was over?
Objection, relevance.
Sustained.
Now, at the end of the day, how long did you work for Justice Willett?
3 years.
And was that always exclusively on the Supreme Court, or did you work for him after he went to the Fifth Circuit?
Just the Supreme Court.
Now, at the end of those 3 years, what was your internship supposed to be? How long was it supposed to last? Your clerkship, excuse me.
Right. Justice Willett had asked that I commit to 2 years. 2 years came and went, and he said I could stay as long as I wanted to. But just with the circumstances that had changed, when I joined the court to work for Justice Willett, I was single. My wife and I got married while I was working there. And then about a year and a half later, we were pregnant with our first kid. So I think it was just a necessary transition from the court to other opportunities.
Right. So where did you go to work after clerking for Justice Willett?
I joined the Office of the Attorney General.
And who interviewed you? Who hired you?
Amanda Crawford, at the time, was the division chief of the General Counsel Division.
And what year was it that you joined the Texas Attorney General's office?
It was July of 2015.
You recall what your first assignment was in the office?
No, sir, I don't.
Okay. And then as time went on, by the time we reached the period of 2019, what was your position?
2019, I was chief of the general counsel division.
What does that mean? What would your responsibilities be?
So I advised the agency as the general counsel, whether it was employment matters or contracting matters, state procurement law, just the typical day-to-day business legal advice.
And then as you went along there, and did you continue to move up within the organization?
Yes.
When was your next promotion?
It was April of 2020.
Now, was Attorney General Paxton already the Attorney General when you joined the office?
Yes, sir.
So your entire career at the Attorney General's office was under the guidance and service of General Paxton?
Yes, sir.
How well did you get to know him?
I might have met him for the first time at an office Christmas holiday party where he and Senator Paxton were taking photographs with employees. That might have been 2 years into my employment, so maybe around 2017. From then until I was promoted to deputy for legal counsel, I might have seen him once or twice at a division chief's meeting, but nothing.
And then what about by the time we approached, let's say, January of 2020? How much contact by that time in your different positions that you had with General Paxton?
He might have contacted me once about a matter, but other than just the typical monthly division chiefs meeting or holiday party, it was nothing substantive.
All right, so we in the jury and the court assume that you yourself did not personally know Mr. Paxton that well at the time.
That's correct.
All right. Were you around him socially other than a periodic office gathering?
No, sir.
All right. Now, when we enter the year of 2020, whom did you have under your supervision in the office?
April of 2020, I was promoted to be the Deputy Attorney General for Legal Counsel.
Does that mean that you were one of the top 8 deputies, or 12 deputies rather, up on the 8th floor?
Yes, sir.
Would you describe, I'm not sure we've broken it down to people, when we talk about the 8th floor, what does that mean in common vernacular for you?
So the 8th floor refers to the 8th floor of the Price Daniel building, where the majority of the executive staff at the Office of the Attorney General have offices.
All right, so when we talk, if the jury is to hear about people where General Paxton dropped into this person's office, this deputy's office, that deputy's office, were all of these offices along the same area, or what was the physical layout?
So if you can imagine, there's 2 elevator banks in the middle of the building, the middle of the floor. And the offices are spaced out around the perimeter of the inside of the building. So each deputy would have an office. There were roughly 3 or 4 offices on one span or one length of the building. So each deputy would have an office.
So my reason for asking, and I'm asking you the answer to this, is that where the office is readily accessible to each other and to the Attorney General, where any of those folks were within a very short distance on the same floor of dropping in or out on each other.
Yes, sir.
All right. Now, when did you first hear, if you ever did, of a person named Nate Paul?
I think it was May of 2020.
And what was the occasion for you to first come? Well, let's back up. What was your position in May of 2020?
I was Deputy Attorney General for Legal Counsel.
Now, how much contact did you have with Mr. Mateer?
We had weekly meetings, one-on-one meetings with Mr. Mateer, Mr. Bangert, and myself.
Now, you're dropping off. I want you to remember that microphone. And maybe you need to move up just a little bit. Or all right. You had these weekly meetings, staff meetings, where there's a day scheduled of the deputies and Mr. Paxton?
So there are deputies meetings that occur weekly, and then there are also one-on-one deputy meetings with Mr. Mateer. So I would meet in all of the deputy meetings, but then I would also meet individually with Mr. Mateer and Mr. Bangert.
And at that time, how old were you?
I would have been 37 or 36 at the time.
And you would have been there at the Attorney General's office since you were about 32 or so?
Yes, sir.
Would you agree that you had moved pretty fast in the organization?
Objection leading.
Sustained.
Sure.
You asked differently.
Yeah. Now, at the end of the day, when you entered into, say, your new position as Deputy General Counsel, what type of matters would that have put you primarily over?
So the Deputy Attorney General for Legal Counsel oversees the opinion writing process, the Open Records Division, the Public Finance Division, the General Counsel Division, and I believe that's it.
All right. So in May, or April or May of 2020, what was the occasion with you becoming familiar with the name of Nate Paul?
There was a pending open records matter involving the Department of Public Safety that had been connected to Nate Paul's name.
Now, at this time, how well did you know Mr. Mateer?
I believe Mr. Mateer joined the office in 2016, if I'm not mistaken. So I'd become familiar with him just in my experience over the past 5 years working at the agency.
What was he like as an administrator and first assistant?
He was great. I mean, he was a people person. He wanted to know how staff were doing. He wanted to connect with each person. He was invested in what they were doing, what they were interested in. He would host book clubs where he would select a book, whether it was a managerial book or leadership book, and we'd meet over a brown bag lunch and just talk about a chapter of the book and how we can implement it in our work and at home. So he was a role model.
Was he religious?
Yes, sir.
How about you?
I am.
In what way?
Objection relevance, Your Honor.
It's very relevant to who these people are in the light of who they've been
Overruled.
accused of. Thank you.
My wife and I attend an independent Baptist church here in Austin. We've been members at different churches here in Austin, and I've been a member throughout my life.
What did you view your duty as an assistant AG to be?
Assistant AG, or as far as Deputy Attorney General for Legal Counsel, I was responsible for providing legal advice to the agency through the various functions of the divisions, whether that was the Open Records Division, the Opinions Division, the Public Finance Division, or the General Counsel Division.
You've heard, have you not, or have you heard, you're being referred to by the Attorney General, all of you, as rogue employees?
Yes, sir.
What was your reaction when you heard that allegation?
It was hurtful.
Why? Tell me.
Sorry. I worked for the state for 8 years as a public servant, as one who values.
May I approach the witness?
Yes.
Thank you. As one who values the commitment to public service, to set an example for my kids, the people that I worked with, the people that I managed. And it's contrary, the statement of being rogue is contrary to the years that I dedicated my life to the state.
How did you become familiar with Nate Paul?
Well, as I mentioned, the first time that I had heard the name was connected to the open records request that was pending at the agency, the Office of the Attorney General, involving the Department of Public Safety.
And did you learn what the issue was about this open records request?
Yes, I did.
And what was the issue?
The Department of Public Safety had received a request for public information. Under the Public Information Act, agencies that desired to withhold information for a valid purpose have to ask for the Attorney General's ruling on withholding information within 10 days. The Department of Public Safety had requested a ruling from the Attorney General's office on whether it could withhold information under the law enforcement exception to disclosure. So in other words, if there is information in the request that qualifies as law enforcement information that is not required to be disclosed, the agency is requesting the Office of the Attorney General to make that determination so that that information can be withheld.
At the time that you began to have awareness of Nate Paul, how would you describe your sense of loyalty and support of the Attorney General?
It was my understanding that General Paxton had met personally with Nate Paul. He considered what had happened to Nate Paul to be wrong, and he wanted us to find a way to help Nate Paul.
And when was the first time? Did you have conversations with the Attorney General about this matter?
Yes.
When did personal conversations with the Attorney General begin in person? Either, well, let me put it in person or by phone or by text, any of that way. When did you first have contact of some type with the Attorney General about Nate Paul?
It was in the month of May of 2020.
And what form did that take, and how did it happen?
I believe it was all in person. There were no phone calls or text messages or emails, to my knowledge.
All right. And when they had these phone calls, do you recall what the Attorney General said in the first one and what the occasion was for that call?
The initial call was a request to pull the file, basically.
By whom? Who asked you?
General Paxton.
Do you recall what he said on the call?
Well, I say it wasn't a call. It was generally in person. So stopped by the office, asked me, I would like to see this file. And so I contacted Justin Gordon, who is the chief of the Open Records Division, and asked him to bring the file to my office.
Now, at that time, had you had any contact with Nate Paul's case yet? Or was the General Paxton's request of you the first time you had become involved?
That was the first time that I was involved in the DPS file, the request at that time.
So, did you get the file?
Yes, I did.
What did you do with it?
I reviewed it and notified the Attorney General that I was prepared to meet to discuss it.
How did you do that? How did you notify him?
Normally, it would have been an email to his scheduler, just to see if he was going to be in the office, to see if we could schedule a time to meet. I don't recall specifically if I emailed the scheduler or contacted his aide. All right.
Did you, when you reviewed it, what all did you do? I mean, how much time did you spend reviewing this file?
It's my recollection, everything was drafted. The initial draft of the ruling was already complete, and it was a standard law enforcement exception was raised, law enforcement exception applies, the information should not be disclosed. So it was a pretty straightforward review.
Did you learn one way or the other whether there had been a previous ruling and finding from the department as to whether or not the law exception applied to the same event that was now happening with DPS?
Mr. President, I believe the objection would be this question calls for the solicitation of hearsay.
I don't agree it's leading, but I'll withdraw it because I don't think it was understandable. So I'll take it back.
For other questions.
Thank you very much. So let me ask you this. When you reviewed the file, did you find out anything about whether or not, what event was being complained of that they wanted access, whose files they wanted access to?
The subject of the event was the August 2019 raid of Nate Paul's home and businesses.
All right. When you reviewed the file, did you find out one way or the other whether this issue had come before the agency once before about the file on the same event?
At the time, I did not connect this event to any previous determination by the office, but subsequently, I did connect the two.
All right. So ultimately, did you discover or connect, as this was the second time around for Mr. Paul and or his attorneys seeking information to overcome the law enforcement exception?
That's right.
Objection leading.
All right. Now,
Sustained.
all right. Now let me ask you this. After you reviewed the file and you informed the Attorney General you were available to meet, was there a meeting?
Yes.
And can you put a time area for us as to when this meeting occurred?
It was in the middle of May, and the reason that I believe that it was between that period is because when the Office of the Attorney General receives an open records request for a ruling, the office has 55 days, up to 55 days to issue that ruling. The DPS ruling was due June 2nd. That was the 55th day. So we would have been discussing it in the middle of May before it was released on June 2nd.
Now, you made a minute. Was there already a draft opinion regarding the matter that was intended to be issued before July 1?
Yes.
Or was it June 1 or July 1? I've got...
June 2nd was the 55-day deadline.
And what was the preliminary opinion that already existed in the file when you started looking at it?
It was to withhold the information under the law enforcement exception.
Now, when you told the lieutenant, the Attorney General that you were available, how soon did you meet with him if you did?
It would have been a matter of days between notifying him and scheduling a meeting in his office.
You met with him in his office?
Yes.
All right. Was anybody else present in the meeting?
There were a series of meetings at which Justin Gordon, the chief of the Open Records Division, and Ryan Banger attended.
All right. So at this first meeting, were they both present?
I don't recall if both were present, but there were just in this meeting and the subsequent meeting, they were both in attendance at one or the other.
What did the Attorney General say in this meeting?
He asked us to review the file. He asked us what our interpretation of the file was. He told us that he had spoken personally with Mr. Paul. He said that he believed that something bad had happened to Mr. Paul. He felt that Mr. Paul was being railroaded by the FBI and by DPS. And General Paxton said that he didn't trust law enforcement. He asked us to find a way to release the information that had been requested to be withheld.
Now, in your experience and your familiarity with the subject, what was your response to that?
Objection hearsay.
It's not. This is the witness. This is his
Overruled.
response. Thank you.
I told General Paxton that if we were to reach the opposite conclusion and to require the Department of Public Safety to release the information, it would upset decades of precedent involving the law enforcement privilege, where law enforcement agencies rely on the protection that the Public Information Act gives it to protect ongoing information, to protect confidential information, to protect witnesses who could be compromised if their names or their identities were released. So there's incalculable problems with reversing the decision to withhold the information and require it to be produced, not just across the state, but with the Office of the Attorney General.
Mr. President, if I may, a lot of this is in narrative and not responsive to the question.
That is exactly responsive. I object to this.
Just state the objection, but sustained. Go ahead.
Thank you. What was your opinion, based on your experience, as the potential danger to innocent citizens who had cooperated with the police, thinking that would be confidential?
It could silence people who might ordinarily comply or speak to the police if suddenly their names or identities could be released.
So what was the Attorney General's reaction when you told him all that? But first of all, the stuff that you just said, is that essentially, in a sense, the information you gave him in explaining what your position was?
Yes, sir.
Did anybody else speak up as well?
Objection, hearsay.
I asked if anybody else spoke up. That is not
Overruled.
thank you. Did anybody else speak up?
Ryan Banger also spoke. I don't recall exactly what he said, other than that
And what was the Attorney General's reaction to all this?
he again insisted that what had happened to Mr. Paul was wrong and that he didn't trust law enforcement.
And did he make any distinction about which agencies, or did he talk about all law enforcement?
It was specifically the FBI and the Department of Public Safety.
And did he say why he didn't trust them?
He said that he compared what had happened to Nate Paul to General Paxton's own personal situation involving the Department of Public Safety and the State Securities Board and the FBI.
Well, were you aware of who provided his security?
Yes, sir.
And who was that?
The Department of Public Safety.
Did he indicate in his comments what his level of feeling or trust or distrust about them was?
Not to me.
All right. Now, how long did when you expressed what his initial opinions were, did he go any further, or how did the conversation proceed?
He asked me if he could obtain a copy of the DPS file.
Had you ever been asked or know of any other time where the Attorney General had asked to see a particular file that it's a public information request for?
No, sir.
So what did you do?
I said that it was possible for him to receive a copy of the file.
And I believe you said this was around May 15th, did you not?
Yes, sir.
Did you provide him the file?
Yes, I did.
Did it have everything in it?
Yes, sir.
Did you take anything out of it?
No, sir.
Can you tell us whether or not in that file you had, there was any brief from the FBI weighing in as to their materials in the file and their position as to whether it ought to be released?
Yes, the FBI had submitted a brief in response to the DPS request.
What was the process or procedure within your department if you have a request for open records, people want to get some portion of it from another agency? What was your policy as to let the other agency weigh in?
The Public Information Act requires state agencies to notify the third party whose information may be at stake that they have a right to submit a letter ruling or a letter brief to the Office of the Attorney General for consideration.
So in these circumstances, would it be normal or unusual for y'all to have notified the FBI there was this request, that the request was to an agency whose files included FBI materials? Would it have been usual or unusual for them to let them know so that they could respond if they wanted to?
So in this situation involving the DPS request, the Department of Public Safety did notify the FBI that its information may be at stake in this request for a ruling. And the FBI responded by submitting a letter brief to the Office of the Attorney General under the ordinary principles of the statute.
Were you aware through these materials and looking through the file that there was an ongoing federal investigation of Mr. Paul at that time?
Yes, it was clear.
Did you take a position with the Attorney General that there was an ongoing, at least federal, I'm not including right now state because I have no knowledge one way or the other, but that there was at least a federal ongoing investigation of Mr. Paul that release of these documents would interfere with?
Objection, leading.
Sustained.
Did you inform him one way or the other did you have discussions with him concerning the topic of an ongoing federal investigation?
Yes.
And what did you tell him and what was said?
It's my recollection that there were discussions about the substance of the brief that the FBI had submitted, the quality of the arguments that they had raised and made.
And did this brief provide details of the ongoing federal investigation?
Objection. That will solicit hearsay, Your Honor.
No, I'm not asking for communication. I'm just asking whether or not it contained details about it.
May I be heard on that?
Yes.
Mr. President, so Mr. Hardin is asking the witness about the contents of some other document that is not currently in evidence, pretty much right down the fairway of hearsay.
I'm not asking for
I'm going to sustain, rephrase your question.
Well, I'm not asking you for specifics of what it said. I am only saying, were there documents and information in this file that were used as the basis of a conversation with the Attorney General concerning the presence of an ongoing federal investigation of Mr. Paul?
Yes, sir.
All right. Now, when you gave the file to him, how did that happen? Did you go to his office? What did you do?
I believe I delivered the file to Andrew Wicker, who was General Paxton's aide at the time.
And did you later confirm that Mr. Wicker gave it to the Attorney General?
Yes.
And how long was it? Will be some intervening events I'll ask you. Well, how long was it after that event that you retrieved your file from the Attorney General?
Well, as I mentioned, when the Office of the Attorney General has to make a ruling, it's on the clock. So we have a timeline. I was notified by Justin Gordon, the chief of the Open Records Division, that we needed to make a decision because the clock was coming up. It was approximately 7 to 10 days before that when I delivered the file to Andrew Wicker, and Mr. Gordon had emailed me asking for a status update.
And so then how long after, back to the original question, was it from the time you gave it to the Attorney General to you? Let me ask you this, was it ultimately returned to you?
Yes, it was returned to me.
And when was it returned? Approximately when was it returned to you?
I believe it was May 28th or May 29th.
All right. And in the meantime, were you part of any later conversations after the one you just relayed, in which you expressed your opinion, the Attorney General expressed his? Well, let me back up. In that second meeting, counting the first meeting being him asking you to look at the file, okay? The second meeting would be the one we just discussed. In that second meeting, did the Attorney General give you any indication as to what he wanted you to do?
Well, he wanted us to find a way to release the information.
And after you expressed yourself, Mr. Bangert expressed himself, the Attorney General expressed himself, in that second meeting, was there a conclusion as to what was going to happen?
No, sir, not that I recall.
All right, how did the meeting end up?
We were essentially at an impasse on our recommendation not to release the information and the Attorney General's decision to release it in some form. We told the Attorney General that we would review our options and follow up with him to see if there's anything else we can look at.
What was his position as to whether or not he wanted or thought the law enforcement exception should apply?
He didn't necessarily take a position that I recall other than something happened to Mr. Paul, it was wrong, this shouldn't be allowed for the FBI and the DPS to get away with.
All right. Now, after that, when was the next time you had any contact with the Attorney General on this matter?
Again, it probably was a matter of days after that, just in line of the timeline and the deadline. We followed up and let General Paxton know that we looked at it again. We didn't think that we could reach an alternative conclusion.
And who was the we in that part?
Ryan Bangert and myself.
And how did you let the Attorney General know?
We met in his office.
And do you recall when this third meeting was?
I believe it was toward the end of May.
And
Counselor, not to interrupt, we're a little past our mid-afternoon break. Is this a good spot,
This
or
is
do you
fine.
want to go?
This is
You're
fine.
here?
Sure.
Okay. We'll stand in recess until 3:30. Mr. Hardin, the floor is yours.
Thank you, Your Honor. Now, Mr. Vassar, I'm just curious, what size is this file? You know, it just occurred to me, everybody's been talking about this file that was the essentially open records request for Nate Paul and all. We've talked about what was in there in terms of descriptions, but what size file are we talking about, just visually?
It was a manila envelope that was maybe a 1/4 inch or less in thickness.
All right, and was it actually contained in a manila envelope?
Yes.
So like have a seal, not a seal, but like a little closing up at the top?
A label.
All right. Did you keep it sealed, or is it just in a manila envelope?
It's just in an envelope, not with the flap on top, but just a folding manila envelope.
I got you. All right. Now, at this time, we are, I think you said somewhere around May 28th, is that right, when the file you're estimating was brought back to you?
Yes, sir.
And that would have meant when you said that you believed you gave it to him around when in May?
The middle of May.
So about, the math would say like 13, 14 days. But you give me what your figure is.
I would say May 23rd.
May 23rd when you gave it to him?
Correct.
All right.
And then when it was returned on the 28th.
I got you. So you didn't have it for about 5 days.
7 to 10 days was what I recall. I apologize for the math.
All right. So, at any rate, that period of time, it was out of your possession to be in the possession of the Attorney General, correct?
Yes, sir.
All right. Now, when you got it back, so let's say toward the end of May, what was the next event or conversation you had with anybody, the Attorney General, concerning Mr. Paul?
The last meeting that we had regarding the Department of Public Safety file was that we did not recommend changing our conclusion to protect the information, but that there might be an alternative solution to take in issuing a ruling.
Why did you come up with an alternative?
General Paxton had asked us to find a way to release the information.
So who came up with a possible alternative?
Justin Gordon, who's the chief of the Open Records Division, had...
And what was that partial, that compromised position?
It was basically taking a position of no position. So we were not making a ruling saying to withhold the information, and we were not making a ruling to release the information.
Had you ever participated in that kind of position before?
No, sir.
Were you aware of it having been done before?
Not until Mr. Gordon suggested it.
Now, I'm not suggesting to you that never had it before happened in my question in the AG's office. I really am just simply asking, were you familiar with it ever having happened before?
No, not in the open records context.
All right. Now, well, what would be the implications of taking a position of no position? Would that be of any advantage to anyone as opposed to declining to release it? Let's do this. Under no position, would there have been 3 possibilities then that you would be treating that request? Here's what I mean. Just a flat out, we're not going to release the information because of law enforcement. That would be one, would it not?
Yes.
Another would be release the information, give it to them as they request. That'd be one, right?
Yes.
And then in the middle of that would be take no position, correct?
That's right.
If you take no position, does that have any different consequences than refusing to turn it over?
Objection. Mr. President, calls for speculation on the witness's part.
Sustained.
All I'm really asking you, I want to try to ask you in a way that's acceptable. I'm trying to determine what is this, why do no position then as opposed to just you can't have it? What's the significance of no position?
General Paxton didn't want for it to appear that his office was aiding the Department of Public Safety or the FBI. And so by taking a position of no position, it was semantics, I suppose.
Well, what is your testimony as to whether if you say no position in terms of what you're communicating to people outside the agency as to the level of resistance you have to resisting?
Objection. Mr. President calls for speculation on the witness's part.
Sustained.
Now, at any rate, was that the decision that was made?
Yes.
No position.
We were directed to take a position of no position.
And in these conversations and all with the Attorney General,
Yes.
had you expressed your position as being opposed to that?
Yes.
Had Mr. Bangert expressed his position as being opposed?
Yes.
Was there anybody else involved in talking about it with the Attorney General?
Not with the exception of Mr. Gordon, who had attended one of the series of meetings.
All right. And was Mr. Gordon have the same position as y'all did, even though he's the one who came up with no position?
Yes. My recollection is his initial review was very flattering of the quality and the content in the FBI's letter ruling.
Now, after that, did there become a separate issue from reviewing the file? At some time, did Mr. Paxton's lawyer's position, Mr. Paul's lawyer's position become, well, we want the unredacted FBI brief?
Objection. Leading and compound.
Well, I'll be glad to rephrase that. Let me give it if that's okay.
I'll sustain it and rephrase.
Thank you very much. So let's go back now. And in that file, was there a brief that had been prepared by the FBI saying why the documents should not be released to Mr. Paul?
Objection. Mr. President asked and answered.
Overruled.
Was there?
Yes, there was.
And you got to speak in the microphone. Is your microphone on?
Yes.
Okay.
Yes, there was.
That's all right. And you're going to find you get tighter and tighter as the day goes on. You got to stay up there. I speak from experience, okay? In this particular case, did the FBI brief, what type of information was in the FBI brief if it was not redacted?
Objection, Mr. President. This calls for hearsay and the contents of a document that is not in evidence.
There's no hearsay at all here. This is simply asking what documents are. These are not communications. This is nothing.
Hold on one second. Overruled.
What type of documents were in there?
The FBI's brief.
By the I say in there, referred to in the FBI brief.
Right. The FBI's brief identified emails, text messages, strategic planning, staging locations for the raid in August of 2019. They identified the task force members. The brief identified a under seal probable cause affidavit that said it was filed under seal, and the FBI brief indicated that that seal had not been lifted.
And so, including all these, when we talk about that affidavit sealed, it was actually under seal at that time in a federal court, wasn't it?
That's what the FBI brief
So the
said.
federal judge has ordered it sealed. It had not been unsealed. But if the FBI brief unredacted was released to the object of the investigation, that person would have all kinds of information that a federal judge had sealed, correct?
Objection, Mr. President. Leading.
I'm asking just, is that correct?
Sustain. Rephrase.
What type of information, without going into the details of the FBI, let me back up this way. In the FBI brief, did they, without saying right now what they were saying, did they lay out sources, names of witnesses, background and history of the investigation, personal data of investigating officers, and personal data on individuals? Was that included in the FBI brief as they argued against its disclosure?
Objection, Mr. President. Once again, this is not, the witness's testimony is not the best evidence of the content of this material. It has not been entered into evidence, and it remains hearsay.
Your Honor, surely we can't keep that information from this record. I'm asking them simply of the types of information was in there.
We'll overrule. You can ask for the types of information.
Thank you, Your Honor.
Limited to that.
So, I believe my question was, in the FBI brief, did they, without saying right now what they were saying, did they lay out sources, names of witnesses, background, history of the investigation, personal data of investigating officers, and personal data on individuals? Was that included in the FBI brief as they argued against this disclosure?
Yes, that was all the content of the probable cause affidavit that I recall.
So, what was your understanding as to whether or not lawyers for Mr. Paul were asking for things to be disclosed by the Attorney General's office that a federal judge had refused to disclose and sealed?
Objection, Mr. President. Leading.
I can
Sustained
ask
asked.
I can ask it another way. Were you aware that a federal judge had placed these documents under seal?
Yes, sir. Based on the content of the FBI brief that indicated that the records were sealed and that the probable cause affidavit was identified as sealed.
So essentially, was the Attorney General of the state of Texas seeking to reveal to a person under a federal investigation the basis of the evidence so far that the government had against him?
Objection. Leading.
Sustained, can you rephrase that?
Sure. Was there a clear clash here between what the judicial system had decided somebody that should be sealed versus a man under investigation seeking the sealed information?
Yes, that was my opinion.
And was the information he was seeking particularly harmful and dangerous to other people, if disclosed?
I believe so, to the extent it revealed the law enforcement information within the probable cause affidavit, the investigators that were involved, and other government officials that participated in the decision.
All right, so how did it proceed now about whether or not, by the way, by this time, can you give us a time frame where all of a sudden they're seeking the FBI brief?
I believe the request was submitted May 24th of 2020. So it was in the middle of our conversations about the DPS file itself.
All right. And did they, when they were seeking it, how long do you think it was before y'all provided an answer?
I think the answer was due sometime in July. I want to say that July 28th.
Of their open records request for the FBI brief? Is that what you mean?
Correct.
Okay.
So if I can lay it out
Yeah, please.
on a calendar.
Please.
The DPS file was due June 2nd. The request by Nate Paul's lawyers to the AG's office for the FBI brief was received May 24th. I believe the deadline to issue that ruling was July 28th, just based on the 45-day or 55-day time period.
Mr. Vassar, if we do this in a time frame, what is your testimony as to whether or not the request for the FBI brief by itself came before the no decision on the release of the DPS file? Did it become before or after?
It came before, because the The DPS decision was not issued until June 2nd.
All right. When the June 2nd position was issued, I believe that was what you said was the no decision. Is that right?
Correct.
All right. Now, anytime after y'all said no decision, was there any attempt anymore by people on that Mr. Paul's position, excuse me, was there any attempt any longer to get access to the whole file?
No, not to my knowledge. So just generically, under the Open Records Act, when the Office of the Attorney General makes a ruling, the parties have the right to appeal that ruling to the district court. I'm not aware if that happened.
That's another way. So to your knowledge, are you familiar whether or not after y'all said no to the DPS file on June 2nd, was there any attempt by Mr. Paul's lawyers to appeal that to a district court as they were entitled to?
I'm not advised of that.
And instead, did they move to be trying to get an unredacted version of the FBI brief?
It's the timelines are suspicious.
And they're suspicious for what reason?
Sorry, Mr. President, I'm going to object to the witness's speculation and unresponsive statement and ask Your Honor to strike it from the record.
Yeah, we'll sustain that and strike that from the record. You can ask any other question.
When you issued no opinion on June 2nd, was there in that no opinion a redacted version of the FBI brief?
No, sir.
All right. As of June 2nd, had they had access to the FBI brief with the probable cause affidavit setting out the basis for the search and arrest?
Objection.
Just give me just a second. I'm sorry.
Please.
Strike the word arrest. There wasn't an arrest. I didn't mean that. Go ahead.
Objection, Mr. President. Calls for speculation. I understand the question to be asking for what Nate Paul's lawyers did or didn't have, unless I misunderstood Mr. Hardin.
Objection sustained.
Would it change if I said he misunderstood me?
Give it a try.
All right, no problem. All right, now let's do this. What was the decision? Did you have any conversations with the Attorney General on the issue of releasing to Mr. Paul the FBI brief?
Yes.
How did those conversations happen? When? Where?
They coincided with our conversations about the DPS file, just given that the timelines overlapped.
All right, so can you estimate the time frame when you talked to the AG about whether to release the FBI brief?
I believe it was the last week of May.
And when you did so, what did you do? I mean, what was the decision? Can you tell me what the Attorney General said?
I had notified General Paxton that the office had received a public information request related to the DPS file, and it was a request for the unredacted FBI brief that the FBI had submitted.
And what was his response?
He asked to see a copy of the two briefs, the redacted version and the unredacted version.
Did you give them to him?
Yes.
What happened next?
We met maybe the next day, and he showed me the two versions that I had sent to him, and he had highlighted and circled and marked up some of the documents. And he stated to me that he didn't see anything in here that should be withheld.
Attorney General of the state of Texas, are you saying, actually went over the affidavit and the brief, all the information that was referred to in the brief, and made circles himself on it?
He marked up the copies of the letter brief that the FBI had submitted to the Office of the Attorney General.
And the Attorney General decided, what had been your advice as to whether it should be released?
Well, the initial step in that process would have been to notify the FBI that the office had received a request for its information.
Did you do that?
Yes, I did not personally, but
Was it done?
it was, yes, sir, it was done.
And what was the status? Were you waiting for their response?
Yes.
What was did the Attorney General have a position about that?
On their response,
Yes.
so it was my understanding that there was a delay in either connecting with the FBI or the correct person to make a decision on whether to respond and how to respond. After a follow-up attempt to contact their office, I don't know the content of that conversation, but I know we made a couple of attempts to contact them.
And then when you were unsuccessful in figuring out who in the FBI to talk to, what happened then?
After mentioning all of these sequences of events to General Paxton, he directed us to let the brief go out.
And he had earlier told you he didn't see anything that was a problem releasing?
That's right.
Do you know anything about the criminal law or practice history that Attorney General might have been particularly informed about to make those kind of decisions?
Objection, Mr. President, calls for speculation.
No, let me rephrase it to make sure it's understood.
Sustained.
Do you know of anything that you've ever witnessed or observed in terms of knowledge, background, or history of the Attorney General to be making a decision about what law enforcement information should and should not be released?
No, sir.
All right. Now, when you released, are you saying that the Attorney General's office released an FBI brief, unredacted, to the subject of a federal investigation, in spite of it having pointed out that the information in there currently was under seal with the federal judge?
Objection, Mr. President, leading.
I don't think that's leading. I can.
Sustained. Sustained.
Pardon me?
Sustained.
All right.
Rephrase.
Tell us exactly what the consequences and what he did when he ordered that brief to be released to the subject of a federal investigation.
So the decision to release the information was done under the Public Information Act in order to reach a decision that the office was required to make in response to a request for information. Based on what I recall, the absence of the third party responding or responding in time or informing the office that it didn't intend to fight the release resulted in a release under the Act.
Well, would you have released it even if you were making the decision? Let me put it this way. You, as a courtesy, tell fellow law enforcement agencies this is under consideration, correct?
It's a required notice under the Public Information Act.
In your processes, are you allowed and able to review law enforcement information from another agency? And even if you don't hear from that agency one way or the other, do you have the authority to declare the law enforcement exception to apply and hold it back even if you don't hear from the other agency?
There are situations in the open records context when the Open Records Division may raise exceptions based on the information that it reviews that may not have been raised by the parties.
In this particular case, what was your position, even when you had not heard from the FBI yet? What was your position as to whether this FBI brief, unredacted, should be released to the subject of the investigation?
I believe that it should have been withheld just based on the content of the document.
And did you argue that position?
Yes.
Did you argue that position even when you had not heard yet from the FBI?
Yes.
And once that information is released, is it released under any conditions, or can the recipient share it with anybody he wants to?
It's not released under any conditions.
So when you release law enforcement information through a Freedom of Information Act or public records request, once that information is out, if anybody wants to find out, what would be the possibility if anybody with larceny in their heart wants to know addresses, names, all kinds of personal information about law enforcement or witnesses? Would they potentially have access to it if the possessor wants to give it to them?
Objection, Mr. President. This is leading and calls for speculation on Mr. Vassar's part.
Sustained.
Mr. Vassar, are you aware that in September of 2020, a, quote, special prosecutor was serving subpoenas using the names and addresses of officials that appeared in the file that your agency released?
Objection, Mr. President.
Are you aware of that?
I'm sorry. Objection, Mr. President.
That is why this is relevant.
Don't talk to each other. What is your objection?
Objection. Assumes facts not established in evidence in this trial, Your Honor.
Your Honor, I swear to you under my oath as a lawyer, you're going to have that evidence presented. Now,
I don't
guess-
have it now.
Pardon me?
We don't have it now.
I know that, but it's coming. My point being is I'm only asking him if he was aware the event happened. When he talks about evidence not be before the court as yet, I'm seeking to find out if he's aware how this information was used. He can say he's not aware, and that ends the inquiry. But if he says he does, it points out the danger of what exactly happened here in this case, which is at the heart of the major impeachment contentions that we have.
Mr. President, may I be heard?
Yes.
I have great esteem for my colleague. However, I promise it's coming is not a proper response to that objection.
Sustained.
Only this question. Was the type of information I talked to you about available then to the recipient once you released the FBI brief?
Mr. President, same objection, same horse, different question.
Still a legitimate question. The question was that available to the recipient? That's all. I haven't asked about anybody else you haven't heard information about. I'm talking about the person in this case, Nate Paul.
In this case, Counselor, I'll overrule.
Was it?
The information that would have been in the FBI brief is what would have been disclosed to the requester.
Thank you. Now, can I move on to was that the last contact? To your knowledge, did the representatives of Nate Paul make any more attempt after you released the FBI brief? Was there any more attempt to get the information from the DPS?
Not to my knowledge.
So what is your testimony as to whether or not, after you issued no opinion, but then released the FBI brief, was there any more attempt to try to get to a fuller file of DPS?
Not to my knowledge.
Thank you. And was any lawsuit, to your knowledge, filed in state court to try to get it?
No, sir.
What did that indicate to you?
They may have gotten the information.
From some other way?
Yes, sir.
All right. Now, if we can, when's the next thing you had to do with Mr. Nate Paul?
Well, unknown to me at the time, Ryan Banger contacted me on July 31st, which I think was a Friday, in the evening, and asked me about a foreclosure opinion.
Did you? And how did that come about? That was, but you remember what day of the week that was?
It was a Friday evening.
All right. And Mr. Vassar, what did you understand that your responsibilities and mission were?
So Mr. Banger contacted me and told me that we needed to look into foreclosure sales.
And did you understand, who did you understand this was a request from, that you were asked to do this?
From General Paxton.
Do you recall where you were when you got the information?
I was at home.
And what did you do as a result?
I responded to Mr. Banger over the phone and told him that I would look into it. I would give him a first draft as soon as I could.
Now, what time of day was it? Was it, first of all, what day of the week was it?
Friday.
And what time was it on Friday night that Mr. Banger called you?
Between 5 and 7. I mean, it was.
And at that time, did you understand in response to the initial call there was any urgency one way or the other?
Yes, it was.
And when the urgency, when were you supposed to try to have this opinion?
As soon as possible.
What did that mean to you? No, it's okay. Go ahead.
I told Ryan that I would get him a draft sometime that evening, if not first thing in the morning.
All right, did you do that?
Yes.
And then what did you do the rest of the morning in connection with it?
Ryan and I spoke about the draft. He agreed with the initial conclusion, which decided that foreclosure sales should be allowed to proceed under the governor's executive order at the time.
All right. And were the two of you in agreement with that?
Yes.
About what time of day did y'all get a document that you thought was sufficient to send over to the Attorney General as a draft?
It was probably 11 to 12 on Saturday, that next day.
What's the next thing you did in connection with it?
Ryan called me not long after that, probably 30 to 45 minutes after he had sent it to General Paxton.
Were you aware as a result of that phone call whether he had talked to the Attorney General?
Yes.
And as a result, what did you understand your new mission was?
I understood that General Paxton said that we got the wrong answer.
All right. So the right answer had been what, in your view?
Well, based on the office's position on numerous COVID-related matters, we had erred on the side of opening Texas, not closing Texas or prohibiting people from gathering. We had issued a number of opinions relating to houses of worship, election issues, and schools, all of them encouraging opening, not closing it. So the initial conclusion was based on my understanding of the office's position throughout the summer.
And did you make a legal determination that that went in line with what you believed the office policy was?
Yes.
And then what happened when you were told you had the wrong answer? What did you do?
I laughed.
Why did you laugh?
I just because I found out that I had gotten the wrong answer when I believed I had reached the right answer just based on the office's position throughout the summer.
All right. So then what did y'all do?
I told Ryan that I would take a look at reaching a different conclusion. I think he volunteered to do that and made modifications to the draft that I had sent him.
Now, you two guys are deputy chiefs of the whole office, right?
Ryan at the time was deputy first assistant, and I was deputy for legal counsel. Yes, sir.
Well, you were pretty high up in the food chain, were you not?
Yes, sir.
How often do you two write opinions?
Rarely.
Do you have any idea why the two of y'all were doing it rather than very capable lawyers underneath you in the litigation section?
I think it was a priority issue that General Paxton wanted someone to get it done as quickly as possible.
All right, so who did the main drafting this second time?
It was essentially the same shell of the first draft, and Ryan Banger revised the conclusion to conclude that foreclosure sales should not proceed.
Were you aware of at that time any contacts that Mr. Banger and the Attorney General were having in drafting the opinion?
I knew that Ryan Banger was speaking with General Paxton.
And were you getting any kind of progress request or not? Were you aware of how often they were speaking one way or the other?
No.
All right. And then was there any challenge to rewrite it?
Well, I mean, we had to go back and adjust the analysis to the extent we could based on the position that we had taken initially.
All right. Now, once you completed it, about what time in the morning on Sunday did you complete it?
I spoke with Ryan throughout the day on Saturday after we were exchanging drafts and trying to reach an opposite conclusion. It's my understanding that he finished around midnight on Saturday evening.
Was he passing on to you, y'all discussing at that time, any involvement in the Attorney General in the editing process?
I was not involved in any conversations directly.
That was going to be my next question. So during that entire evening that night, is it correct to say you were not dealing with the Attorney General, only Ryan was?
That's right.
Okay. Now, once it was produced, at any time during that process, did you have any idea whether or not this was something that would or would not benefit Nate Paul?
No, sir.
Did you later change your opinion or your sense of awareness?
Objection, Mr. President. This calls for speculation.
I'm only asking about his mind state. I'm not asking anybody.
Overruled.
Thank you. Go ahead.
Yes, sir. I believe Monday, or I think it was Tuesday.
And what changed your mind Tuesday?
Well, foreclosure sales across the state are held on the first Tuesday of each month. So when the opinion was announced on our website on Sunday at roughly 1 in the morning, a foreclosure sale was reported in the media to have been...
Objection, Mr. President. Any reports in the media would be obvious hearsay and inadmissible.
Sustained.
All right. All I'm going to ask you is, did news reports provide you information that changed your sense of awareness?
Same objection.
I'm not asking you what you heard, not asking you what you read, not asking you any hearsay or anything. Just simply, did news reports later change your sense of awareness, whatever that was?
He's just asking about did it, not what was in them. Overruled.
Yes.
All right. Now, at the end of the day, did whatever that opinion was, did that concern you, and if so, why?
Well, not at the time. It was odd, but it wasn't concerning because at the time I had no context for who was involved or what it was for.
And then once you did have a context about who might be involved, did that change? What was your reaction to that?
It was even stranger that we would have gone through that effort to become involved in a potential Nate Paul related issue involving foreclosure sales.
Okay. Now, after that opinion was done, did you have anything else to do with anything that Mr. Nate Paul and his businesses did, whether it was later bankruptcy or any other events? Did you know anything else? Do you have anything else to do on that front, on foreclosure front, with Mr. Nate Paul or his affairs?
No, sir.
All right. Now, let's go to the final area I want to talk to you about. Was it tell us what your responsibilities were if somebody above you or below you wants to do a contract with an outside lawyer. Let's start here. What was the policy generally of getting outside law firms within the agency? How would that happen ordinarily?
So ordinarily, with an agency of 800 lawyers and 4,000 employees, there are sometimes a need to retain outside counsel. That could be because it's a specialized area of law. Maybe it's intellectual property law, where the Office of the Attorney General doesn't employ IP lawyers. It could also be a local counsel issue. If the state of Texas wants to intervene in a Virginia case, the office would need local counsel. So there are unique instances where we would have engaged outside counsel to represent the agency. All of those requests are managed by the General Counsel Division, which I oversaw in my role as Deputy Attorney General for Legal Counsel.
Well, now, how often in your memory have you ever recall outside counsel being retained to do a criminal investigation?
None.
Ever?
No, sir.
All right. And why is that?
Mostly just because the prosecutors and the attorneys in the office would handle that work.
So when did you first become aware that the Attorney General wanted to hire an outside law firm for a criminal investigation regarding the complaints of Nate Paul?
Well, the first time that General Paxton contacted me, I believe, was in the middle of August of 2020.
And what was the nature of that contact?
He wanted to know what the basic process was to retain outside counsel.
What did you tell him?
I told him exactly what I just explained to this chamber of there has to be a request, there has to be a specific need. The attorneys have to be vetted to ensure that there's no potential conflicts of interest. And there's a formal approval memorandum and a outside counsel contract template that is signed by the attorney and the Office of the Attorney General. So
can we have our exhibit, 160, please, Stacy. Is that not in evidence? All right, we moved into evidence. 160. Thank you.
No objection at all, Mr. President.
Show 160 be admitted into evidence.
Now, I'll represent, well, you tell me, what is exhibit, do you have a hard copy?
It's on the screen right now.
Okay. Do you recognize what it is?
I do. It's an email from myself to General Paxton's Proton Mail email address dated September 3rd of 2020.
Now, that's a different type of email address than the official Attorney General email route, isn't it, or is it? What is a Proton address?
I'm not sure. I believe it's a private email service.
Well, it's been suggested by his lawyers that that's very frequently used in your organization. Is that true? And is a Proton email address, in addition to your official one, very commonly used with the people in the office?
Objection, Mr. President. Lack of foundation and calls for speculation by Mr. Bassett.
No. They can't do what they did. You heard the cross-examination in this kid talking about how common and ordinary it was and everything. Surely I'm allowed to ask this witness if that's true.
Mr. President,
That's all I'm doing.
I'm sorry, Mr. President, I believe we've invoked the rule and perhaps should not be talking about what other witnesses testified to with this witness.
I was getting ready to say that.
Pardon me?
I was getting ready to say that.
Yes.
Sustained, and you should not be talking about other testimony given in that specific instant.
Well, let me ask you. If one were to contend it is commonly used within your agency to have a Proton email address, would that be accurate or inaccurate?
Objection, Mr. President, calls for speculation.
Your Honor, this is really...
Yeah, overruled. Go ahead.
Thank you.
Not to my knowledge. I've never, not to my knowledge. It would not be ordinary to me. I am not even sure what it was.
Yes, I'm not trying to suggest it's never done, but in your experience, have you frequently or infrequently been dealing with official business in your agency with the Proton email address?
Objection, relevance.
I asked whether he...
Overruled.
Yeah, thank you. Go ahead.
No, sir.
All right.
This could be the first time that I had used that email address for General Paxton before I hadn't seen it before.
How did you know to use it here?
I think I asked him for his email address that he wanted me to send the contract to, the draft.
The general himself?
Yes, sir.
So are you saying that 5 years you've been there, this email address is the first time you ever used it in dealing with him?
Objection, leading.
I'm asking, just try to be clear.
Sustain the objection, but rephrase.
Thank you. In this particular case, do you recall when he gave you this, how did he ask you to do it, first of all? Did he call you, drop in on you, or how did this happen?
The first time was a phone call when he asked about the basic process for retaining outside counsel. The second, he came into my office on September 3rd, and he instructed me to draft a contract for Brandon Kamek.
And then did he tell you at that occasion where to send it?
Possibly. If I didn't follow up with him to ask him, he could have instructed me in my office on that day of where to send it.
Ordinarily, if you sent it to his regular official agency email address, who would have access to it?
I believe the assistant has access to his email box. I don't know if he had access.
Would this Proton address be on access? Would other people be? Is there any way other people would be aware of it or ultimately run into it? If you sent something at this address, does that become available to others, or would it be only to the user of this email?
Objection, Mr. President.
If you know.
calls for speculation, lack of foundation, assumes facts not in evidence.
I'm not asking for any, I don't know what facts are not in evidence I have talked about. I simply trying to find out is if this is used, would that then be restricted in availability to the Attorney General? That's all I'm asking.
And Mr. President, what I will renew is my objection that there is no foundation laid for Mr. Vassar to know anything about what the other agency employees can access or cannot access.
Sustained.
Now, when you sent him this contract, did you draft anything in there that was a little different?
Well, I drafted the scope of work.
And when the Attorney General asked you to do the draft, was anybody else around you when he asked you to send it?
No, sir.
Did he describe to you what he wanted this person to get a contract for?
Yes.
What did he tell you?
It was my understanding that Mr. Kamek was being hired as a second set of eyes, if you will, to review the Travis County District Attorney's referral of the complaint involving Nate Paul.
And had you been ever asked to do that in the criminal law area before?
No, sir.
When was the last time you had done an outside agency contract for somebody to do a criminal investigation?
I can't recall one.
Does that mean you don't remember any?
That's right.
All right. So when you did that, did you pay attention to a particular concern as to how to limit the scope of work?
Yes, sir.
Why did you do that?
Well, the referral from Travis County used specific language about providing assistance to Travis County.
Did you look at it at the time, the referral?
The first time I was given a copy of the referral from Travis County was September 3rd.
Were you aware at that time, one way or the other, of any conversations and disagreements that had been occurring internally as to whether Mr. Kamek should be hired to do this? Were you aware through talking to other people or any other source?
Objection, Mr. President. That response would call for hearsay.
I've not asked for the statements yet. I've asked if he was aware of anything.
I'm going to sustain. Would you re-ask the question?
Thank you. So, at that time, were you aware of any other concern about this matter, namely Mr. Kamek being hired to review a criminal investigation or whatever the assignment was? Were you aware one way or the other as to whether there was any opposition by other people in the organization to hiring Mr. Kamek for this project?
Objection, Mr. President. That would be derivative of hearsay.
I have asked simply whether he's aware of...
Overruled.
Thank you.
He can answer.
Are you?
Yes, sir.
Is that another reason you wanted to be cautious?
Objection, leading.
All right, that's fair enough.
Sustained.
Are you? Thank you, Judge. Were you, because without going into what you said, had you had conversations before September 3rd with the Attorney General about this matter?
Yes, sir.
When did you have your first conversation with him about it?
The first time would have been when he asked about the basic process. That would have been around August 15th.
And at that time, did he talk to you at all about what he had in mind?
No, sir. It wasn't until the week of August 26th, I believe, when I was on vacation, General Paxton called me and asked me to explain the process, the basic process, to two individuals.
Did he mention Mr. Kamek's name?
Yes.
What did he say to you?
He just asked me to contact both of the individuals, explain the process to them, and that these were the two individuals that...
The other person, why two individuals? Was there somebody else under consideration?
There were two names that General Paxton gave me.
And what was the other name he asked you to prepare a potential contract for?
Joe Brown.
All right. Mr. Joe Brown had been a previous U.S. attorney, had he not?
Yes, sir.
All right. Now, so did you prepare a contract like we just introduced for both Mr. Kamek and Joe Brown?
No, sir.
All right. Whom did you prepare the contract for exclusively?
So the only contract that was prepared in this matter was for Brandon Kamek.
And why did you not do one for Mr. Brown?
Based on when the Attorney General came into my office on September 3rd and directed me to prepare a contract for Brandon Kamek, it was my understanding that there was no longer any need for a contract for Mr. Brown.
All right. I want to take the contract now. Stacy, if you could put up, I moved to introduce 160. I'm not sure. I got a reaction one way or the other.
Mr. Hardin, you admitted it.
Thank you.
Yes.
Yeah, it's admitted.
Thank you, Your Honor. I want to move on this contract of September 3rd over to the addendum. Can you go to the next to last page, which says Addendum A? You have that?
Yes, sir.
And is there a portion of this contract and this addendum that you can direct the court and the jury to that will show how you tried to restrict the scope of activity in this contract?
Well, and again, this was all drafted based on my understanding of General Paxton's decision of what Mr. Kamek should be doing, as well as the conversations about the Travis County referral and the extent to which it authorized our office to assist. You can see that the first paragraph specifically refers to certain criminal violations made by state and federal employees. So there's a singular referral that this contract is referring to.
It says, does it not, that this is to be a review of the allegations, correct?
That's correct.
One could review the allegations just by looking at them, right?
That's right.
Object to the sidebar. Move to strike.
It's not a sidebar, it's a question, Your Honor.
You can strike the word right.
Okay. And a review of the allegations, which include complaints of potential criminal violations made by certain state and federal employees. Were you aware at that time of any of the details of what was in Mr. Paul's complaint?
When I drafted this scope, that was the first time that I received a copy of the referral and a copy of the complaint.
And when you looked in the referral, when you looked at the documents that Mr. Paul had provided the Travis County DA's office and that they sent over to the Attorney General's office, what type of allegations did you note as to what type of people and conduct this young man was to look into?
Based on what I recall, Mr. Paul had alleged that certain members of the FBI and the task force, the Department of Public Safety, may have taken his phone from him or not allowed him to contact his attorney. They may have damaged property searching through evidence. I don't recall the specific nature of the allegations other than just...
Were there allegations about improper conduct by a federal magistrate?
Yes, sir.
Did that give you pause?
It did.
Well, all right. So when you see these kind of allegations, then how did you draft it to try to take care of that, in your opinion?
Well, the last paragraph refers to conducting an investigation under the authority of the OAG, which would be derivative of the complaint, which is to assist. Towards the end of the paragraph, it explains that notwithstanding anything else, outside counsel should only conduct an investigation consistent with the complaint and only as directed by the Office of the Attorney General, meaning that any activities that he wanted to pursue should have been authorized and approved by the office.
And in it, as the way you structured this, do you make any reference in there to this man becoming a special prosecutor?
There's a plain exception that says that the legal services under this contract do not include any other post-investigation activities, including but not limited to indictment or prosecution.
So, as you believed when you drafted this contract and circulated it to be approved by others, what did you think this contract was setting out, giving him the authority to do if it was approved?
In short, he was to review the allegations in the complaint, the statements in the complaint, prepare a report that would be returned to our investigators to provide a second opinion to General Paxton.
And those investigators of yours would have been of who? Who would they have been turned over to?
David Maxwell and Mark Penley. David Maxwell was the director of law enforcement at the office, and Mark Penley was the deputy attorney general for criminal justice.
Did you have discussions with the Attorney General that this is what he was authorized to do? Or did you have any, first, did you have any conversations with the Attorney General about this?
Yes.
About this restriction?
About the nature of the services that Kamek was being hired for, yes, sir.
What did you say to him?
I just explained that we can't, the OEG, the Office of the Attorney General, cannot ordinarily engage in a criminal investigation except for a referral, a case of a referral. General Paxton explained that he had a referral from Travis County, and then I explained that even under a referral, we wouldn't have an outside counsel representing the agency in a prosecutorial role.
What was his reaction?
He didn't have one that I recall.
All right. And so then, after you have done this, what kind of process it was supposed to go? When you sent this to the Attorney General, did you get a response from him?
No, sir.
Did you hear back from him on this?
Not that I recall. When he asked me to send him a draft of the contract, he also asked me to send it to Brandon Kamek.
Well, so if I can, I move to introduce 161, please.
I don't see this on our list.
I'm moving to introduce it. I believe it's not in evidence.
Okay.
No objection, Mr. President.
Stella, could I have a hard copy, please?
There are no objections. When you receive it, Mr. Harden, you may.
Thank you very
We'll
much.
admit 161 to evidence.
Thank you. Now, would you identify this for me on September the 3rd? Now, I'm sorry, Your Honor, may I have just a second? Mr. Vassar, I want you to look at 161. I want you to look at 161 and see if that is basically the same document that you had sent the same day on September 3rd, except that this one is to Mr. Kamek. Is it the same document?
Yes, sir. That's right.
All right. So now you have forwarded a contract to Mr. Kamek and the same contract to the Attorney General. But what all would be necessary to happen before this became a true contract and Mr. Kamek authorized to work for the Attorney General? What would be necessary?
So ordinarily, when the Office of the Attorney General wants to engage an outside counsel, that has to be approved internally through what was referred to at the time as an executive approval memorandum. That memorandum would explain the background of the request, the nature of the legal authority through which the agency could act, and the amount that was likely to be expended.
All right. In this situation, if you're going to go through the matrix for the contract, would you explain on this type of procedure what would it be the process? How many people would have to approve of this?
I'll run through them very quickly, but generally the process would start with the General Counsel Division Chief. It would next go to the Financial Litigation and Charitable Trust Division. Budget would be next. I believe I would be next in line as the Deputy Attorney General for Legal Counsel. Given the nature of the services involved criminal justice, Mark Penley, the Deputy Attorney General for Criminal Justice, would have been next. I believe Lacey Mays was next.
Well, in y'all's process, does anyone what happens if anyone along that chain refuses to accept it or approve it? What happens?
Basically, the request is denied, but it could be revived based on further conversations.
All right. In other words, everything stops if somebody declines until at least it's talked about more? Is that what you mean?
Yes, sir.
All right. So what happens if the Attorney General goes out and unilaterally hires somebody without sending it through the process at all? In your opinion, could he do that?
Yes, sir.
All right. He has the authority, right?
Yes, sir.
He's the guy. Okay. Now, if in fact, are you familiar with why y'all follow those processes, though, that you've just described that would be in the ordinary situation? Why do you do it that way?
Mainly for efficiency purposes, but also just to ensure that each decision is vetted by the divisions that may have input or advice on the specific
All right.
issue.
So are the people that are put on there division heads of the divisions that are affected by the contract?
Yes, sir.
So in this contract, what all divisions would be affected that would have to okay it?
The General Counsel Division, the Financial Litigation and Charitable Trust Division, the Budget Division, myself, the Controller, the Agency Controller, the Deputy for Administration, the Deputy for Criminal Justice, the Chief of Staff, and the First Assistant.
It's like 8 people, isn't it?
There's a lot.
Hey, thanks a lot. All right. Now, let me ask you, in the emails that we looked at, or in this document, 161 is a contract, earlier some emails where we looked at 160, 160 is the contract that goes to Mr. Paxton. 161 is a contract that goes to Mr. Kamek. Is that correct?
Yes, sir.
And then you go, if you want, 228, contract 228. Not contract, exhibit 228. Well, hold that, please. Don't put that hold on. I'm sorry, Joe. I apologize. I want to ask you I want you to look at 166. I believe this is already in evidence, Your Honor, because I think it's already been up on the screen once.
Yes, it is.
Thank you very much. 161. Now, I want you to look at this and describe for everyone whether this sets out the approval level it has to be done. Does it?
Yes, sir.
All right. Now, this is the contract that is to be the process to get Mr. Kamek's contract approved, correct?
That's right.
So it starts out with Joshua Godby, the Charitable Trust Division. Why would he have to approve it?
So the Financial Litigation and Charitable Trust Division manage the Office of Attorney General's outside counsel contracts.
Do y'all ever approve a contract that hasn't been the agreement to fund it? Who has to agree to fund it?
The Budget Division has to approve funding.
All right. Let's go up. Then Josh Godby, after him is Ryan Vassar. Who drafted this particular document?
I did.
All right. And how did you know what to put down here under the synopsis and background?
Just based on my understanding, again, of the nature of the services that Kamek was being engaged for.
Excuse me.
Mr. President, I believe there may be some distrust over whether this document is actually in evidence. We do not object to it. It has not been offered.
Yeah, we're just relooking at that now. So it was not entered, but you do not object? Is that correct? Pardon? Okay.
I believe it was shown by an earlier lawyer on your side. I think you had
It was a pretrial
yeah.
issue that didn't come in.
Are good.
But you're good. Go forward.
Thank you very much.
Did not
Joe.
object.
No, thank you. Thank you very much. Now, let's,
Excuse me, for the record, 166 is admitted to evidence.
thank you very much. Now, so you prepared over on the second page, or it says page 1, but it's second when you turn it, the synopsis of what happened in the background and all of that?
Yes, sir.
I want you to tell us in your own words, when you sign off an initial, this particular contract, did you sign off as if you approved it?
Yes.
All right, why did you do that?
I concluded, based just on my position of whether the agency had lawful authority to hire an outside counsel, Brandon Kamek, in this situation, that it did.
So you understood who wanted to hire him?
Yes.
Who was it?
General Paxton.
Describe it in your own words that he made clear he was going to do it.
Yes.
So did you have any doubt whether or not that's what he was instructing you to do?
No, sir.
When you draft it, put a synopsis and initial it. Tell us in your own words, what was your position then as to whether this contract should or should not be approved?
So based in my position as deputy for legal counsel, my role was to recommend based on whether the agency had lawful authority to act, not whether it should act. So in my review, I determined that Kamek, as outside counsel, could provide legal services to the agency to investigate or to review the complaint referred by Travis County.
And what would be your position as to whether he had the authority if he stepped outside the scope that you had drafted so carefully in the addendum A?
Objection, Mr. President. That would call for speculation.
Sustained.
Was he authorized to do more on behalf of the Attorney General's office than you set out in the scope A of the contract?
Not in the draft that I wrote.
All right. Now, when you sent these two contracts, or these proposed contracts, that you've just raised an issue right there. Were these drafts or were they final contracts?
They were both drafts.
So at the time you sent these out to Mr. Kamek and to the Attorney General, what was necessary to make them a binding contract where the Attorney General's office had actually legally hired Mr. Kamek? What process was required?
Objection, Mr. President. This actually calls for a very important legal conclusion. And this witness is not qualified to reach that conclusion on the ultimate issue.
I'm asking him what process within his organization was necessary for it then to be, at least him to consider it, a complete contract with the agency. Let me put it that way.
That is a different question than the one you asked.
So I'm going to sustain the first objection. I'll sustain.
But he's allowing the second one. Is that
Well, you can start the second one now.
Thank
One
you.
more time.
All right, thank you. So what was necessary in your mind as the person responsible for both drafting and initiating these contracts to make the drafts you sent to Mr. Kamek and to the Attorney General? What was necessary as far as your procedures and your experience and in your opinion to make it a contract that where Mr. Kamek was actually officially hired and entitled to be paid under the contract?
Objection, Mr. President. That question is extremely compound. There are several questions in it. Procedures, policies, his opinion may be very different things.
Sustain.
The contract that you sent, had it been signed by anybody?
No, sir.
To be a binding contract as far as you would be concerned and the agency and your responsibilities, whom did it have to be signed by to be a binding contract?
Under the agency's signature delegation policies at the time, it would have been Jeff Mateer.
All right. And if the contract at that time was signed solely by Mr. Kamek, do you have a contract, or does it have to be signed by somebody that can bind the agency along with Mr. Kamek?
It would have needed to be signed by the agency as well as funding obligated to pay for the services.
So did we ever get to that process that you were aware of at this time?
It was started, I believe June 4th, we started the internal approval process.
And that's the internal process. It's circulating it to the people on Exhibit 166?
Yes, sir.
Just to correct the record, the witness said June 4th. I believe you mean September 4th. Is that correct?
That's right, September 4th.
I'm sorry?
Let the record reflect September 4th.
Okay. The cover sheet would be 166, would it not? The contract, I believe, were the 164. 161, I'm sorry. I just want to make sure we got it straight.
Oh, I'm sorry. Were you talking to me?
We've got
Be
166.
best to speak to the court. And
166 is what I introduced that you accepted. And that's a copy of the approval sheet. And that's what I was
166 is on the screen.
asking. I'm sorry, that's what I was asking about.
don't talk over each other. Yes, sir.
166 is on the screen and it has been admitted.
Pardon me?
You can continue, Mr. Hardin.
I'm sorry, I'm all confused.
166 has been admitted.
Right.
166, correct?
And I thought you were changing the number on me.
I'm sorry. I'm confused by your statement. Maybe this would be a good time for a break.
All right.
In about 15 more minutes. About 15 more minutes, we'll have a break.
All right, thank you. So let's try to move through this real quickly. Did it start going through different procedures, and what was the outcome of this contract? Did it ultimately go all the way, or did it stop somewhere along the way?
It stopped
The
along
approval
the way.
process. And where did it stop?
Mark Pendley declined to sign the approval memorandum.
And when did you become aware that Mr. Pendley would not sign it?
I don't recall the exact date. I recall there were conversations that when I signed it, it would go to Mark Pendley next. I advised Jeff Mateer that that was going to be the next line in the sequence. I also advised Mark Pendley that he was going to be next after I signed it. I don't recall exactly when Mark Pendley declined to sign.
I think there are other documents that we can introduce later that would show that. We'll do it through other people. As to your involvement, Mr. Vassar, how would you view your role once you started sending out the drafts? Did you start having contact personally with Mr. Kamek, where he would have several different requests that you would communicate with him, or what?
I was the point of contact for Mr. Kamek just based on the introduction through General Paxton. After the internal approval process had started, I received a call from Mr. Kamek. I believe it was around the 13th of September.
What did he want?
He asked if there were any official documents or an official email address that we could give him.
And at some stage along the line, were there inquiring about whether he was going to have inquiries by him as to where he was going to have credentials?
I'm sorry, could you say that?
Was he going to have credentials? Did that ever become an issue that would show that he was authorized to work on behalf of the AG's office?
No, sir.
Did you ever provide him any?
No, sir.
Did he ask you for any?
He did on that phone call.
And what did you tell him?
I told him that he didn't have a contract yet. I didn't understand why he needed credentials to identify himself as representing the agency.
All right. Were you aware, what was your level of awareness as to whether Mr. Kamek, or belief, was authorized to be speaking for the AG's office before this process was completed? What was your belief?
He had none. He had no authority to represent the office.
In your opinion, when would he have had authority to represent the office?
When?
Yes.
When he had a binding and executed contract.
And did he ever, to your knowledge, have a binding and executed contract?
Objection, Mr. President. This once again calls for a very important legal conclusion that goes to the heart of the matter.
I'm not asking him for a legal conclusion.
Witness can answer the question if you know of your own personal knowledge, not on hearsay.
On October 2nd, I believe Brandon Kamek sent a contract that appeared to be signed by General Paxton and Mr. Kamek himself.
Do you know when you first saw that?
I believe it was October 2nd.
Is that the first? Describe for us, were you aware before, any time before that, that General Paxton had decided to sign the contract on behalf of the Attorney General's office?
No, sir.
Did you have any idea at that time when you saw it on October the 2nd, how and when that happened?
No, sir.
Did Mr. Paxton ever tell you that he had signed a contract personally with Mr. Kamek?
Yes, he did.
When did he tell you that?
I believe it was Friday in October, which may have been the 3rd. He emailed me and informed me that he had signed the contract with Kamek and that there had been a mistake in Jeff Mateer's letter terminating the contract as an invalid agreement.
We need to jump ahead a little bit for this particular portion. You're aware, or you're not, that, well, let me ask you, do you recall what date you and a group of people went to the FBI to report your concerns?
September 30th.
All right. And are you aware then when y'all informed the Attorney General that you had done so?
October 1st is when we notified General Paxton.
And after you informed the Attorney General, did it sometime on either September the 30th or October 1, had Mr. Kamek been sent a cease and desist letter?
Yes.
And whom did he send a cease and desist by whom sent him a cease and desist letter?
I believe Mark Penley sent a letter to Mr. Kamek, and Jeff Mateer sent a separate letter to Mr. Kamek.
And then separately was action taken in the courts concerning the subpoenas, grand jury subpoenas, that Mr. Kamek had obtained and was serving. Was there separate action undertaken by either Mr. Penley or Mr. Mateer?
Mr. President, we object as to leading.
Are you aware of any?
Abstain.
Excuse me. Are you aware of any action that had taken, personally aware of any action that was taken in the courts concerning the subpoenas that Mr. Kamek had been serving?
Mr. Penley moved to quash the subpoenas.
All right. And so then when you get a letter, did you get a letter from the Attorney General? And if so, what date that was, or text?
It was an email indicating to me that he had signed the contract with Brandon Kamek and that Jeff's letter telling Kamek to cease and desist was improperly sent.
All right. At that time, during that first week in October, when we got to October 3rd, what was your status with the agency?
I was still employed.
And had Mr. Mateer resigned the day before, October 2nd?
October 2nd. I believe he resigned on Friday.
All right. When he resigned, had he sent a letter to Mr. Kamek before that, if you know?
Yes.
And at that time, were all of these actions being done with the involvement of each of you deputies that had been called colloquially the whistleblowers?
Yes.
Now, before that, when this contract, what was your involvement as far as the contract for Mr. Kamek once Mr. Penley refused to sign off on it? What happened then?
From what I recall, Mr. Mateer and Mr. Penley sent a cease and desist. Mr. Kamek followed up to our agency mailbox, just the general mailbox, with invoices that he had purported to work under some authorization from General Paxton. Because we didn't have a record of a contract or a copy of a signed agreement, we informed Mr. Kamek that we could not pay him, and his response was that he had a signed
What date was that?
I believe it was October 1st.
All right. And during the time that you were going back and forth with Mr. Kamek about the contract, were you the person that was communicating with him?
He had emailed me directly, but the rest of the conversation was through the general mailbox that he is.
Did he send you an invoice seeking to be paid?
Yes.
Do you recall when he did that?
It was right around the same period, so it would have been October 1st.
And when he sent you an invoice to be asking to be paid, what was your response?
We informed him that we did not have a record of a contract under which to pay him.
And did you tell him you need a contract signed by somebody within the agency
Well, we just told him we didn't have any contract with his name on it.
that had been signed by anybody?
Correct.
So what did he do?
He responded and said that he had a signed contract.
Do you recall what date he told you that he had a signed contract?
He provided it to us in the morning. I believe it was October 1st. Or no, I apologize. It was September 30th because we went and met with law enforcement on September 30th.
And did you get a contract from him that had been signed by the Attorney General before you went to law enforcement?
Yes.
Now, at the time this was all going on, were you willfully and totally involved in the actions that were decided and that led to you going to law enforcement?
Yes, sir.
Why did you go?
I formed a conclusion just based on my good faith
Here,
belief
keep it to the microphone.
that General Paxton was using the power and authority of his office to benefit a private individual.
And what was your opinion as to whether or not y'all had done everything you could to stop him before that?
Well, all of these sequences of events ranging from May of 2020 to the foreclosure letter in late July and August of 2020 and the CAMIC issue in August and September of 2020 in isolation were just activities that we tried to handle for General Paxton.
Mr. President, I'm sorry, I must object as non-responsive to the question.
Well, let me continue with
Sustained.
you. Yeah, Mike.
Re-ask the question.
Thank you. Now let me ask you this. What was your state of mind in terms of the degree that you, in your opinion, of the degree that you and others had engaged in to try to dissuade him from this conduct that you disagreed with?
We had repeatedly suggested that the positions that we were being asked to take were contrary to established law and policies. When we did that, he directed us to find a different way. So as lawyers do, we found alternatives, and those were the alternatives that he chose.
Well, then what was the tipping point about September the 29th or 30th that led you to decide to go en masse to the FBI?
Well, it became clear at that point that the degree and the extent to which General Paxton appeared to be using the office to benefit a single private individual, to target and harass law enforcement, rose to a level that, just based on our good faith belief, criminal activity had occurred. And under no circumstances did Brandon Kamek have any authority, either under a contract that was unsigned or a contract that was signed, or by some deputation by Travis County District Attorney's Office to serve as a special prosecutor for the Office of the Attorney General. So he was representing himself in a capacity that did not exist, and doing so for the benefit of a single individual.
Under those circumstances, did you feel that the Attorney General had any authority to appoint a, quote, special prosecutor?
No, sir.
Objection, Mr. President.
Did,
The objection is relevance. I don't believe that there is any contention on the part of the House Board of Managers that General Paxton appointed a special prosecutor. That is not the allegation.
Sustained.
are you aware as to whether or not Mr. Kamek was going around and serving grand juries subpoenas claiming he was a special prosecutor of the Attorney General's office? Are you aware one way or the other as to whether he was doing that?
Objection, that would call for hearsay.
No, it doesn't call for hearsay. This witness can be cross-examined about what his basis of his knowledge is, and then he can say whether it's solely hearsay.
Overruled it.
Thank you.
You may answer the question.
Yes, sir. I'm aware.
And in fact, was Brandon Kamek ever hired by the Attorney General's office by anyone in the Attorney General's office and designated a special prosecutor?
No, sir.
And what is your opinion as to whether or not they even had the authority to hire a special prosecutor in this case under the facts that you knew him to be?
Objection, Mr. President. Lack of foundation, speculation, and relevance.
Sustained.
Mr. Vassar, what was your concern if y'all did not go to the law enforcement on September the 30th of 2020?
Well, the concern was that it would only get worse. General Paxton's use of the office would only continue to be more extreme, to benefit Nate Paul, and the potential for us to be labeled as co-conspirators.
How long did you remain with the Attorney General's office after October the 1st, 2020?
I was terminated November 17th, 2020,
And what was the stated reason for terminating you?
for disclosing confidential information outside the agency.
And did they describe to you or give you anything in writing to tell you what confidential information you were supposed to have disclosed?
No, sir.
Did you ask for a meeting to find out what it was?
I asked what it was, and they didn't provide a response.
Who replaced Mr. Mateer as the first assistant after Mr. Mateer resigned?
Brent Webster.
Is he still acting as the first assistant to your knowledge?
Yes.
Did you, without going into other conversations, did you seek to find out what confirmation or what information was being used to terminate you? And did you ever find out what it was?
Yes. I asked Mr. Webster what information I had allegedly disclosed outside the agency, and he didn't give a response.
To this day, do you know what confidential information you were supposed to have revealed?
I have not received a direct answer, but based on the agency's own internal whistleblower report, they've made allegations.
Finally, when you were terminated, how old were your children by then?
6 months to 4 years.
I believe you indicated, but I'm not sure I remember. How long did it take you to find another job?
6 months.
How did you live?
Just on savings that we had saved.
And when you took another job, where is it now?
Yeah, it's for a local nonprofit policy think tank here in Austin.
At the end of the day, in light of all that, and by the way, have you sued? Are you a whistleblower that has sued the Attorney General in the state of Texas?
Yes, sir.
Why did you sue?
Mainly for my family.
What do you mean?
Well, to take care of them financially, but also just to be a good example for them.
And what do you mean about a good example for them?
Just to stand up for the truth.
You read this report that they put out back in 21?
Yes, sir.
You saw what it said about you?
Yes, sir.
You saw what it said about the others?
Yes, sir.
How would you rate the level of accuracy of the report that Mr. Webster says he primarily prepared?
On a scale of 1 to 10, I'd give it a 2.
And was that report been out on the internet to the world at large?
Yes, sir.
All about you and the others being rogue employees?
Yes.
Is this the first time you've ever had an opportunity to tell your side since this all happened?
Yes, sir.
You feel better or worse?
It's not fun.
I'll pass the witness.
We'll break now until 5:25, and members, there are some snacks back in the back for you to get a little energized, and we'll come back for about another 60 to 90 minutes, depending on how it goes.
Mr. Murr, I've got it.
Your witness.
Thank you, Mr. President. Mr. Vassar, my name is Mitch Little. I'm with the law firm of Sheaf and Stone, and I represent the elected Attorney General of Texas. We've much to discuss. I'm going to try to pick up a few crumbs here. The word that I heard at the end of your testimony was co-conspirators. Do you remember that word coming out of your mouth?
Yes, sir.
One of your concerns on September 30th was that if you didn't go to the FBI immediately, someone would think you were co-conspirators with the elected Attorney General in this state, right?
That was one of the concerns, yes, sir.
And your attorney that you hired before you went to the FBI is a man named Johnny Sutton, correct?
That's right.
And he's here today, correct?
He is.
And he's sitting in this courtroom, yes?
Yes, sir.
Would you indicate him for us?
It's right there.
Yes. And he represented a number of you employees at the Attorney General's office, correct?
Yes, sir.
And by the time that you went to the FBI, Mr. Vassar, just tell these senators, did you know who performed the home repairs and renovations at the Paxton's home?
No, I had no direct knowledge.
You didn't have any indirect knowledge, did you?
It was discussed when all of the events came together and we met as deputies on September 29th. That was mentioned as one of the potential concerns of bribery of the Attorney General.
Who mentioned it?
Based on my recollection, it may have been Mr. Brickman.
And Mr. Brinkman heard it where?
I'm not sure.
He heard it from someone else, correct?
I'm not sure.
You don't know.
I don't know where he heard it.
But one of the criminal complaints that you and your group of people who went to the FBI alleged was that the Paxton's home was being renovated at the cost of someone who was under federal investigation, correct?
You said one of the criminal complaints. I'm not, we did a verbal complaint
Yes.
at the office, but I'm not sure.
Let me be clearer. One of the things that you told the FBI in your meeting with them was that you were concerned that someone else was paying for the home renovations to the Paxton's home, correct?
Me individually, I had no knowledge, but yes, in the meeting with the FBI, with all of us present, there was a roundtable discussion about some individual's good faith belief that the Attorney General was involved in bribery.
A good faith belief based on what?
I'm not sure. It wasn't my direct knowledge.
You were in the meeting.
Yes, I was in the meeting with the FBI, but
What was the basis?
I'm not sure. I think it was redoing the kitchen countertops.
Redoing the kitchen countertops? Is that what you heard?
I'm just giving you the context of what I recall.
Did you see any documents exchanged with the FBI in this meeting?
No, sir.
Not one.
No, we did not provide any documents to the FBI.
And let me be clear, because I think your testimony was a little bit confusing, at least to me. It may have been to the senators as well. But you learned about Brandon Kamak's signed contract with the Attorney General after you reported the Attorney General to the FBI, correct?
I think that's correct, yes.
So when you went to the FBI and you told presumably some FBI agents that Brandon Kamak was out serving grand jury subpoenas without authority, you did not know that that man had a signed contract with the Attorney General of this state's signature affixed to it, correct?
That's my recollection.
Well, surely when you found out, you went straight back to the FBI and told them, right?
No, I mean, at the time
No?
we were represented by Mr. Sutton.
Surely at that time, Mr. Sutton asked you to go back to the FBI and correct that misinformation, correct?
What information, what misinformation? That Mr. Kamak had a contract?
Yes, he had a signed contract affixed with the signature of the elected Attorney General of this state, correct?
Yes, based on what he had provided to us was a signed contract, and General Paxton had confirmed to us that he had signed a contract.
And you had it in hand, correct?
Yes.
And surely your lawyer said, guys, we need to go back to the FBI and tell them that there's a signed contract with the affixed signature of the elected Attorney General of this state, right?
There wouldn't have been any reason to provide them with a signed contract because that wasn't part of the complaint that we had filed with the FBI.
Part of the complaint, let's be clear about the complaint, okay? Part of the complaint to the FBI was that Brandon Kamak was out serving grand jury subpoenas to support someone else's agenda besides the people of the state of Texas. True?
Yes.
And at some point after your meeting with the FBI, you discovered from Brandon Kamak that he had a signed contract with the elected Attorney General, correct?
That's absolutely true, for nothing that he was doing.
And I'll object to the non-responsive portion of the question or answer and move to strike, Your Honor.
Strike the last comment.
Now, let's be clear about something else. After this contract that was signed by the Attorney General of the state of Texas, Ken Paxton, he had the authority to enter into it, correct?
Yes, I believe he did.
And that's because over 4 million voters in this state gave him that authority, correct?
Yes.
And that authority exists to bind this state. And if the voters don't like it, they can vote in someone else, correct?
That's, yes, how the political system works.
That's my understanding as well. At what point in time did you come back to the FBI and say, well, maybe there was some authority for Brandon Kamak to do what he was doing? Did you ever do that?
No, sir. And just because
Object non-responsive to anything after no, sir, Mr. President.
Please keep your answers to the questions.
In your meeting with the FBI, did you tell the FBI that Ken Paxton had illegally disclosed some confidential material to someone?
we've filed a complaint based on activity that we had formed a reasonable belief that.
Mr. President, I will object at this time as non-responsive.
Sustain.
Madam Court Reporter, would you mind reading my question back? I should have a, I'm sorry, I don't have one. Yes or no?
I disagree with the phrasing of the question.
It's a very simple question. Did you tell the FBI in this meeting, did someone in this meeting tell the FBI that Ken Paxton had illegally disclosed some confidential information to someone? Yes or no?
In the meeting, we alleged, based on a reasonable belief, that that activity could have occurred, but we were not investigators. That was what law enforcement was for.
That's right. And Mr. Vassar, I want to see us on this point. You're a lawyer and you're doing some, I mean, you have very good command of the language. You had a good faith belief in certain information, but you didn't know that Ken Paxton had disclosed anything to anyone when you made this report to the FBI, did you?
No.
You were hoping the FBI would sort it out for you and not think that you were co-conspirators with him, correct?
No. The purpose of the complaint to the FBI was because we had formed a belief in good faith that the Attorney General was involved in criminal activity.
This is something that I keep hearing over and over again. We formed a good, let me make sure I get it right, formed a good faith belief that the Attorney General of this state was engaged in illegal activity. Did I say that right?
That's accurate.
But you didn't know, right?
Well,
You didn't know, right?
that's the point of the good faith belief, is we had no evidence that we could point to, but we had reasonable conclusions that we could draw.
You went to the FBI and reported the Attorney General of this state with no evidence. Do I have that correct?
We reported the facts to the FBI.
That's not my question. You had no evidence that Ken Paxton had done anything illegal. Did you?
Your Honor, it's not necessary to yell at this witness. I suggest it's disrespectful, and I request he quit doing it.
I apologize. Let me do this again at a lower volume. Madam Court Reporter, would you read my question back for me, please, at an appropriate volume? Yes.
Repeat that, so, because they could not hear her on the microphone.
Yes, Mr. President, I will. You're watching the live stream over there? Hold on. Let me ask this question again. Let me get this straight. You went to the FBI and reported him for potential crimes without any evidence. Do I have that correct?
We went to the FBI and reported
Please answer my question, yes or
our
no.
belief that criminal activity had occurred.
That was not my question. That was not
Witness
my
needs to
question.
answer the question, yes or no.
Did I ask it again, Mr. Vassar?
Please.
I want to get this straight. You went to the FBI on September 30th with your compatriots and reported the elected Attorney General of this state for a crime without any evidence. Yes?
That's right. We took no evidence.
Did you gain any after that? Did you gain any after that?
Well, we weren't collecting evidence.
Did you gain any after that?
Evidence of what, sir? Of
Evidence of a crime committed by the elected Attorney General in this state, elected by over 4 million voters. That guy.
I don't recall if we had collected any evidence.
Don't you think that's something that you should be able to recall, sir?
Well, when we presented ourselves to the FBI, we did so as witnesses, not as investigators to collect evidence.
Did so as complainants, hoping that you would not be named as co-conspirators, true? You made a complaint, yes?
Yes, it was.
Without any evidence, yes?
No.
I'm sorry?
Again, these are our good faith beliefs that a crime had occurred.
Respectfully, sir, we are not here in this historic event for your good faith beliefs. So if you could just tell these senators who are taking up their time and all of Texas's time with this impeachment.
Excuse me, these sidebar testifying comments are an inappropriate form of cross. If you just asked a question, I have no objection.
I will throttle it down. I withdraw it.
Pull that back.
Yes.
Ask a question.
Mr. Vassar, we got a lot of people whose time is invested in this impeachment proceeding. Did you gain any evidence after you went to the FBI?
I'm not sure what evidence that I can recall.
You had a good faith belief. We've heard those words a lot in this trial, a good faith belief, but without any evidence, correct?
The evidence that we provided.
Why didn't you talk to Ken Paxton? I'm sorry.
Please let him finish his answer.
Overruled, he was finished.
Mr. Vassar, when you worked for Ken Paxton, was he gentle?
As far as I knew, yes,
Be
sir.
kind?
Yes, sir.
Ever yell at you, scream at you?
No, sir.
Don't you think you owed him the courtesy of at least a phone call before you reported a man to the FBI without a shred of evidence?
Well, that's not how the reporting structure worked.
Oh, please tell these senators how it works.
Well, all of my interactions were directly with Jeff Mateer and Ryan Bangert. General Paxton would call me with questions like the open records issue or the foreclosure letter, or I'm sorry, not the foreclosure letter, that was through Ryan Bangert, outside counsel. So every other instance was my weekly meetings with Jeff Mateer and Ryan Bangert. And I never called the Attorney General. He always called me.
I appreciate your answer, but that was not really what I asked. So let me try again. Don't you think you owed the Attorney General of the state of Texas at least a phone call before you reported him to the FBI without any evidence? Yes or no? That's not the way it worked? Yes or no?
Would you like me to answer?
Yes, I would.
Based on our conversations with Mr. Mateer and Mr. Bangert, they were having conversations directly with General Paxton. I was not part of those conversations. So any concerns that they had raised with him would have been in their conversations. I had no reason to call him directly.
Object non-responsive.
Sustain.
Let me try this again, Mr. Vassar. Don't you think you personally, Ryan Vassar, don't you think you owed the Attorney General of the state of Texas, elected by over 4 million voters, a phone call before you reported him to the FBI without any evidence, sir?
I was appalled at the time, so
Object non-responsive.
Sustained.
I object to the continued interruption of the answer. If he doesn't like the answers he's getting, he can then object to it being non-responsive. But jumping in the middle of this, man, is totally unfair, and I object.
I will listen more closely, Counselor. I have not heard him interrupt him. I will listen more closely so the witness can finish his answer and you can do a follow-up question.
Thank you. Can we go
That
back to my
objection's
question?
overruled.
Thank you. May I go back to my question, Mr. Vassar? My question was, don't you think you personally owed Attorney General Ken Paxton, elected by over 4 million voters, a phone call before you reported him to the FBI without any evidence? Yes or no? No, I don't? Yes, I do.
well, I would disagree that we didn't have any evidence just based on our beliefs, but I don't think I owed General Paxton anything.
You don't? You worked for him for 5 years.
That's right, and I believed in him.
He gave you a job, correct?
He did. And promotion.
And a promotion, huh? Not enough to warrant a phone call before you report him to the FBI, though. True?
Like I said,
Do you wish you could go back and call them?
I'm sorry,
Do you wish you could go back in time and call Ken Paxton and talk to him before you reported him to the FBI without any evidence?
I wouldn't do anything else differently.
Interesting. Okay. You don't know anything about Ken Paxton's campaign donations from 2018, do you?
No, sir, I don't.
You didn't work on the Mitty Foundation case, did you?
No, sir.
When you went to the FBI, did you have Ken Paxton's phone number, at least? Could you call him on his cell phone? Did you have the number?
I believe I had his phone number in my phone. Yes, sir.
How'd you get it?
I think he gave it to me,
Why?
just based on working with him and questions that he would call me with.
So you could call him if you needed something, so he could call you if you needed something, right?
That could be an option, just based on a cell phone use.
You even had his secret email address, didn't you?
I'm not sure which one is.
Well, there is an email that's already entered into evidence in this case. It's ag.wkp@protonmail.com. Have you seen it?
Yes.
He gave it to you, right?
Yes.
Did you email him on his secret email address? Tell him that you were going to go and report him to the FBI without any evidence?
No, sir.
Why not?
It didn't occur to me.
Didn't occur to you. At some point since then, has it occurred to you that maybe you should have done that?
No, sir.
How secret could this email address have really been, Mr. Vassar, if you had it?
I don't know exactly.
Do you consider yourself a close confidant of the Attorney General?
No, sir.
Do you think you're the only person that had that email address?
I have no reason to believe that I was the only one.
So this gentle, kind man, was he attentive to your concerns when you talked to him in the office? Talked to him on the phone?
Sure.
Gentle, he's kind, he's attentive. And at what point in time did the weight of what you were doing in reporting this gentle, kind, attentive man to the FBI become apparent to you?
On September 29th.
When you walked in there?
Walked in where?
To the FBI.
No, that was September 30th.
Okay. So what happened on September 29th when the great weight of having to report this gentle, kind, attentive boss struck you? What was going on?
September 29th, I was in a meeting, just a division meeting with Lacey Mays, and she received a text message on her phone from an individual that I did not recognize, and the individual asked if a Brandon Kamek was working for our office.
And you knew exactly who that was, didn't you?
Yes, I recognized the name.
And what happened in your mind was you realized this contract didn't work its way all the way through the executive action memorandum process. True?
Among other things, yes. That's a thought that went through my mind.
Yes, and the rest of that thought is, if that process has not been completed, he has no authority to work on behalf of the Office of the Attorney General, correct?
Yes.
And that was alarming to you, true?
In addition to the fact that he was acting in a capacity that he didn't have, even if a contract had existed at the time.
And in that moment, did you call General Paxton and say, Brandon Kamak's working, what's going on?
No, sir.
Do you think it's possible? Is there room in your mind for the possibility that if you had called Ken Paxton and told him that information, Ken Paxton would have said, yeah, Ryan, I signed the contract with my own hand, with my own pen. Is there room in your mind for the possibility that that would have happened?
Well, it is possible, but he was out of the state at that time. So I wouldn't have been connected to him or had a reason to call him.
You had his phone number. So what if he was out of the state? Cell phone works out of the state, surely, right?
Yes, sir.
You didn't think to call him?
Well, as I explained, because he was out of state, Jeff Mateer was running the office.
That's another thing we're going to get to, okay? My understanding is your belief was that while Ken Paxton was in Ohio working on the Google case, the biggest case that the Office of the Attorney General had, Jeff Mateer was the acting Attorney General, right?
That's correct, although my understanding, in addition to
An object is non-responsive to the remainder of this answer.
Sustained.
Mr. Vassar, can it possibly be in a state with as many millions of people as Texas has, that it is the belief of the upper echelon of the Attorney General's office that any time the Attorney General gets on the plane, Jeff Mateer is the real Attorney General?
only to the extent the government code is triggered. That's what deputizes the first assistant to act under the authority of the Attorney General.
And your belief was that on September 29th and 30th, when Ken Paxton was in Ohio doing business on behalf of the people of the great state of Texas, litigation business, very important litigation business, that someone else was the Attorney General, and that's what the government code says. Is that right?
Well, it was my understanding it was a political event. It was a campaign event. I had no knowledge that he was working on the Google case.
He was doing a campaign event in Ohio?
That was my understanding at the time.
Where on earth did you get that?
Just conversations at the time with Mr. Mateer.
So if he was on, let's say he was in Ohio on a campaign event, Jeff Mateer's the Attorney General while he's there?
I was just clarifying my understanding based on your question. Your next question of whether Jeff Mateer is the acting Attorney General, again, that would depend on the statute. The statute provides if the Attorney General is absent or unable to act, the first assistant shall perform the duties.
Tell the senators what absent means.
The statute doesn't define it.
Tell me what you think it means.
Well,
Out of the state?
It would mean the ordinary meaning of the word under a statutory interpretation approach.
Tell these senators, many of whom are very accomplished attorneys, what the word absent means to your understanding, please.
I am not advised of what the dictionary definition would be. That would be an interpretive guide. Absent could mean out of state. Absent or unable to act could mean incapacitated.
Like if Ken Paxton was on life support in a hospital somewhere, for example.
I presume so.
But he wasn't. He was in Ohio, which I guess is debatable one way or the other.
I'm not aware if that statute has ever been interpreted by a court, so I could not be able to say.
But in any event, it provides the perfect cover for someone in your office to remove Ken Paxton's name for the letterhead and begin sending out letters on behalf of the Attorney General of the state of Texas. True?
No, nobody removed his name from letterhead.
You don't think so?
No, sir.
Have you ever seen Attorney General's office letterhead without Ken Paxton's name on it?
All the time.
All the time.
Yes, sir.
How did correspondence in September of 2020 come to be sent to parties outside of the Attorney General's office without Ken Paxton's name on it? Tell us.
Well, the agency has different letterhead. There probably even today, letterhead that's available on the Attorney General's website that does not have his name on it.
So-
Letterhead that he signed.
I see. So when the Attorney General is absent in Ohio, someone at the office goes, grab me the letterhead without Ken Paxton's name on it. He's in Ohio today. Is that right?
I don't recall any decision about using this letterhead or who instructed the use of the letterhead.
No one decided, it just happened, right?
Like I said, I don't recall any decision about it. The agency has different letterhead that exists today.
You're familiar with the Mitty Foundation now, right?
I've heard of it, yes, but
You've been an attorney how long?
I was licensed in 2012, so 11 years.
You said your family goes to a Baptist church, right?
Yes, sir.
Okay, that Baptist church is organized as a nonprofit, right?
Yes, sir.
And at some point in time, I'm sure you've given money to a charity, correct?
Yes, sir.
I got to ask you something that's just been really bothering me, and I know I'm not the only one. What in the heck is a charity doing making a multi-million-dollar private equity investment with Nate Paul with charitable funds? Any thoughts on that?
I'm not sure. I don't know.
You ever ask anybody?
No, I was not involved in the Mitty case, was never consulted on it or provided any advice for it.
Do you know, maybe you do you know of any charities that make multi-million-dollar private equity real estate deals with charitable funds?
I have no personal knowledge.
Okay. Do you recall giving testimony to the House Board of Managers and being questioned on video by Aaron Epley, Brian Binkin, and Therese Buse?
Yes, sir, I remember.
But they never put you under oath, did they?
Not that I recall.
Did that kind of surprise you?
I didn't think anything of it.
Did you ask why not?
I don't know. I don't think I did.
Well, just because you weren't, well, you are an attorney, obviously. Just because you weren't under oath doesn't mean that you didn't tell them the truth, the whole truth, and nothing but the truth, so help you God. True?
That's right.
Did you review your statement in preparation for this historic trial?
No, I consulted with my attorneys, and that was it.
Did anyone give you a copy of it?
A copy of my statement?
statement, yes.
No, sir.
So anything that you said in that testimony, I guess we can call it testimony, anything you said in that testimony that's recorded, we can take as the gospel truth, right? Yes?
Just based on my telling the truth, is that what you're asking?
Yes.
Yes, sir.
We can take it as being true, yes?
Yes, sir.
Okay. Have you ever, before today, have you ever in your life been asked to give testimony as a witness without being sworn?
I don't recall. I've been a resource witness to many Senate and committee hearings, but I don't recall if there's an oath administered to a resource witness. So I apologize.
Have you ever given sworn testimony anywhere before today?
No, I don't think so.
It's a tough first outing, isn't it? Mr. Arroyo, if you would, Article 1 of impeachment, please. Can you see Article 1 on your screen, sir?
Yes, sir.
You don't know anything about this, do you?
No, this would be the Mitty Foundation matter.
And just to be clear, Have you looked at Chapter 123 of the Property Code to determine what the Office of the Attorney General's obligations are with regard to charities in this state?
No, sir.
Don't know anything about that, do you?
No, sir.
All right. Mr. Arroyo, Article 2, if you would. Now, Mr. Vassar, you've given some testimony about what we'll call the foreclosure opinion, right? It was issued August 1,
Yes, sir.
issued August 1 of 2020. Yes?
Yes, I believe that's right. It was a Sunday.
That opinion was not a legal opinion under Subchapter C, Chapter 402 of the Government Code, was it?
Yes, it was a legal opinion under Subchapter 402.
It was?
Yes, sir.
That's not what you told the House Board of Managers. What did you tell them?
I don't recall.
We'll get to that later, but that's not what you told them, is it?
I don't recall. I may have misstated.
You may have misstated.
If you're saying that's not what I said, and my testimony today is that there's no other statutory authority except for Chapter 418 of the Disaster Act to issue a legal authority, to issue a legal opinion by the Office of the Attorney General. So it either has to be Chapter 402 or it has to be Chapter 418.
But we know this is not 402 because it says on the face of the foreclosure opinion that it is not under 402, correct?
It does say that it's not, but that doesn't mean it doesn't fall under the authority of that chapter. It just means it wasn't written in accordance with the typical legal opinion process.
I was hoping that we would be able to have a chance to discuss this. Mr. Arroyo, please bring up Section 402.042 of the Texas Government Code. No, we're looking for 042. That's .212. We'll get to that later. Thank you. While Mr. Arroyo is bringing this up, I've got a couple questions for you about that. In order for the foreclosure opinion to have been authorized under Chapter 402 of the Government Code, Mr. Vassar, certain criteria need to be met. Is that correct?
I believe so.
There first needs to be an authorized requester, correct?
That's correct.
Who are the types of persons who are authorized to make that request?
The governor, the lieutenant governor, the speaker, chairman and chair people of committees of the House and of the Senate, executive heads of agencies, and county and district attorneys.
Did any of those people request the foreclosure opinion?
Yes, sir.
Okay. What is the next criteria to satisfy for Chapter 402 of the Government Code?
You're going to have to refresh my recollection.
All right, Mr. Arroyo, if you would move to the second page of that PDF that you just had up. There you go. If you could just highlight the text at the top, that big chunk of text there. A little bit lower. Thank you so much, and just blow that up for us. Let's look at item C, okay? You're a lawyer. We can read this together, right? Right?
Yes, sir.
It says a request for an opinion must be in writing and sent by certified or registered mail with return receipt requested, addressed to the Office of the Attorney General in Austin, or electronically to an email address designated by the Attorney General for the purpose of receiving requests for opinions under this section. Did I read that correctly?
Yes, sir.
That didn't happen with the foreclosure opinion, did it?
I'm not advised if it did.
You were in charge of the section. Is there anybody who has more knowledge about this than you, perhaps?
I don't have access to the email box that it would have been received at. So I'm not aware of how it was delivered, if it was delivered by electronic mail.
Can you tell the senators whether the criteria of Section 402.042C were satisfied. Yes or no?
I'm not sure. I don't recall.
And that you were in charge, right?
Yes, sir. Subsection D allows...
Seems kind of, I'm not talking about subsection D. We're not there yet. Seems kind of important to know whether this satisfies the criteria for the Attorney General to provide formal legal advice. Yes?
Yes, sir.
But you told the House Board of Managers this foreclosure opinion was not formal legal advice, correct?
That's correct.
It was not formal legal advice. It was informal guidance. True?
I believe so.
And during COVID, the Office of the Attorney General was dispensing informal legal advice related to COVID almost every day. Was it not?
It was very frequently. I don't know if it was every day. But
Were you writing the opinions?
some of them, yes.
People who are working for you were writing the opinions as well. Yes?
Yes.
And there were all kinds of COVID opinions coming out almost every day, informal legal guidance from the Office of the Attorney General that did not satisfy the criteria of Chapter 402 of the Government Code. True?
I'm not sure about that. A lot of the things that you're referring to about the daily stuff would have come through Chapter 418, which is the Disaster Council legal function. Those would have come from county mayors or city mayors, county judges, and emergency management directors. Those were coming more frequently than the other ones.
Well, let's build two boxes. In this box, we have Chapter 402, formal legal advice, correct? Okay? So in this box, we place formal legal opinions from the Office of the Attorney General that satisfy the criteria of 402.042. Yes?
Sure.
And it's assigned a KP number, correct?
That's right.
And it's published in the formal opinions section of the office's website, correct?
That's right.
And to be clear, for the ladies and gentlemen of this jury, the foreclosure opinion did not satisfy anything in that box, correct?
No, that's why it was flagged as not a formal legal opinion.
It's in the 418 box. Because at that point in time, the governor of this state had decided to empower the Attorney General to give the people of Texas guidance more freely about what's going on during COVID. True?
That's not true.
It's not true?
That's correct. It is not true.
How did the Attorney General get the ability to give people informal legal advice under Chapter 418 of the Government Code?
It wasn't from the governor. The legislature enacted a statute that the governor signed, giving the Attorney General the power to advise three categories of people: county judges, city mayors, and emergency management directors.
I apologize for my imprecision. So at this point in time, these people, the legislature, at least in part, had empowered the Attorney General to give informal legal guidance more freely. True?
To select people, yes, that's true.
Yes. How select were they?
It's the three categories of people: county judges, city mayors, and emergency management directors under the Disaster Act.
There were people on the House Board of Managers who were requesting informal legal guidance relative to COVID, weren't there?
But that wouldn't have triggered Chapter 418. The only other express statutory authority for a legal opinion is 402.
But if it doesn't have a KP number and it doesn't satisfy the criteria of 402.042, it's not formal legal advice, correct?
That's correct. It's not a formal piece of advice. It's an informal piece of advice under Chapter 402.
One of the things that had to do with your termination, I believe, is you're voluntarily sending secret grand jury subpoenas outside of the Office of the Attorney General to someone who is not authorized to receive them. Do you understand that?
That's never been stated to me, but that's my understanding based on the OAG's whistleblower report.
Well, you don't have to wait for the OAG to tell you that. You know you did it, right?
I only sent copies of records to my private lawyer. I did not send them to any member of the public or disclose them to the public outside of the agency.
Was Johnny Sutton authorized to receive secret grand jury subpoenas from Travis County? Yes or no?
Well, on their face, they weren't valid. Brandon Kamek had no contract. He was not a special prosecutor. He had no authority to request them or to obtain them.
Mark Penley thought they were valid enough to quash and to get a judge to sign an order to quash them, didn't he?
Well, because they were issued.
They were issued. And when they were issued, they were secret. True? True?
I guess unless they were invalidly obtained under false pretenses.
Are you aware of some type of exception that allows you to send secret grand jury subpoenas to your lawyer?
Well, I thought sending it to my lawyer for purposes of legal advice would be permissible. I'm not a...
Did you check and ask Mr. Sutton whether he represented any of the subpoena recipients before you sent them to him?
Yes, in our conversation for him to represent us, we discussed whether he was able to do so.
And after you sent those grand jury subpoenas to your lawyer, copying the rest of the so-called whistleblowers, you deleted that email from your inbox. True?
That's right.
I think you will probably recall at some point in your 5 years of employment at the Office of the Attorney General receiving some type of training in document preservation. Yes?
Yes.
And what types of training did you receive? Please tell the ladies and gentlemen of this jury.
I believe it's an annual information security training. There's annual sexual harassment training. So there's a variety of required annual trainings that employees of the office are required to complete.
In a second, I'm going to ask you, well, let me ask you now. You are not allowed to delete official records of the Attorney General's office. True?
Official records, no. That's right. Unless...
in a second, I'm going to ask you whether you deleted emails from your computer that should have been preserved as official records. Do you want to consult with your criminal attorney first?
No, sir.
Did you delete official email records of the Office of the Attorney General, sir?
I deleted emails to my personal attorney under the agency's own information security policy that's provided to every employee that personal messages of a de minimis nature are allowed on agency devices, provided that those messages are deleted to prevent archival. Because I made a determination that I emailed Johnny Sutton in my personal capacity with copies of records, not records that had to be maintained on an agency device, but copies of records that existed in the office, I deleted the personal message to Johnny Sutton.
It seems, Mr. Vassar, that one of the things you are accusing Ken Paxton of doing is by allowing people outside of the Office of the Attorney General to see secret things they should not see. Do I have that correct?
No, sir. Mr. Sutton was my personal lawyer.
No, that wasn't my question. Let me try again. Listen to my question. One of the things that you are accusing Ken Paxton of doing is forwarding secret information of the Office of the Attorney General to people who should not have it. Yes?
That is a suspicion.
You don't even have enough to make an accusation. You suspect that it occurred, right?
Yes, sir.
But that's what you did, isn't it?
No, I forwarded it to my personal lawyer for purposes of legal advice.
And you think that protects you somehow?
Well, if any ordinary person gets a subpoena, I imagine their first call is to their lawyer who reviews the subpoena.
In preparing the foreclosure opinion, Ken Paxton didn't direct you. Ryan Bangert did, yes?
Yes, sir.
And Ken Paxton didn't direct Austin Kinghorn. You did,
That's
correct?
right.
If you would, Mr. Arroyo, please bring up Article 2. This allegation is not true, is it?
Is there a specific part that you'd like me to review, or?
Read it all. Ken Paxton is innocent of this allegation, isn't he?
So the first provision of the second sentence, this is Article 2 of the Articles of Impeachment. Paxton caused employees of his office to prepare an opinion.
Hold on a second. I don't want you to read it out loud.
Okay.
We don't need to waste the jury's time doing that.
Sure.
They can read. Many of them are skilled attorneys themselves. This article is not true, is it?
Well, it is true that he caused employees of his office to prepare an opinion in an attempt to avoid the impending foreclosure of properties.
But you don't know whether those properties belong to Nate Paul or business entities controlled by Nate Paul, do you? You don't know that.
Nothing other than what's been reported in the media.
You don't know that what's been reported in the media. Have you ever heard the phrase self-licking ice cream cone before?
No, sir.
Let me explain to you what a self-licking ice cream cone is, Mr. Vassar. A self-licking ice cream cone is when a bunch of employees at the Attorney General's office begin to suspect their boss. They read it in the media. They believe what the media says. They report it to the FBI. And then the media reports that you went to the FBI. That's a self-licking ice cream cone. Are you familiar with the expression now?
Based on your description, yes, sir.
You don't know whether this article is true or false, do you?
No, sir, I didn't write this.
Mr. Arroyo, Article 3, if you will. Article 3, thank you. You weren't directed to act in contravention or contrary to the law, were you?
No, sir. General Paxton.
Object non-responsive to anything after no, sir, Mr. President.
Sustained.
Do you think that your decision with regard to any open records request that was made by anyone was improper?
No, sir.
It wasn't, was it?
No. Everything that we did in a way that we could find a way to make it lawful, because we wouldn't have participated otherwise.
You did it by the book, correct?
Yes, sir.
You wouldn't do it any other way, would you?
That's right.
Mr. Arroyo, Article 4, if you will. Can you see Article 4, Mr. Vassar?
Yes, sir.
And Paxton didn't improperly access anything in his office that you're aware of, did he?
No, not that I'm aware of.
And if he wanted to ask for a file, he could do that anytime he pleased, couldn't he?
Sure.
Because that's what 4.2 million voters elected him to do. True?
Yes,
To
that's
access whatever file the heck he wants. Yes?
true.
Article 5, please. We know that Ken Paxton's innocent of this article, right? Right?
I'm not even. I don't recall the distinction about an attorney pro tem. I used to know it, but
You don't even know what an attorney pro tem is, do you?
I know there's two categories. One is court appointed and one is recusal based, but I don't recall the nomenclature.
And Brandon Kamak wasn't either one of them, was he?
He said he was on the subpoenas.
Stop there. Brandon Kamak wasn't either one of them, was he?
No, he had no authority.
Wasn't an attorney pro tem, was he?
Your Honor, he keeps interrupting the witness. He should be entitled to finish his answer.
You're right, Mr. Hardin. I apologize, Mr. President. May I try again?
You may try again.
Mr. Kamak was not an attorney pro tem ever, to your knowledge. True?
Like I said, I don't recall the distinction between the two categories of prosecutors, but he was not hired to be a prosecutor.
He wasn't hired to be any type of prosecutor, true?
Yes, sir.
He was hired as outside counsel because that's how you drafted the contract personally, yes?
Yes, sir.
So when it says Warren Kenneth Paxton misused his official powers by violating the laws governing the appointment of prosecuting attorneys pro tem, Brandon Kamak wasn't a prosecuting attorney pro tem, was he?
Not based on my understanding of what that...
I didn't think so either. Article 6, if you would, Mr. Arroyo. You're familiar with this allegation dealing with whistleblowing, correct?
Yes, sir.
Don't you kind of think Ken Paxton had a right to be upset with you reporting him to the FBI without any evidence?
I suppose he's entitled to whatever feelings he may have felt at the time.
Article 10, if you would, Mr. Arroyo. This says the Paxtons, and it says Ken Paxton, but you understand he's married to Angela Paxton, right?
Yes, sir.
So when somebody's spouse gets accused of bribery, and the form of the bribery is improvements to a home that are owned by both of them, really you're accusing both of them of being corrupt, right?
I don't know.
Don't you think?
I don't know the elements of bribery. I'm not a criminal lawyer, so I'm not sure what the implication could be.
As you sit here today, you know darn well that the Paxtons paid for the renovations and repairs to their home, don't you?
No, I don't know that, actually.
You don't know who paid for them?
No.
Maybe it'll come out in this trial. Mr. Vassar, would you expect to be placed on investigative leave for sending a set of secret grand jury subpoenas to your outside counsel and then deleting that email?
No, sir. I mean,
You wouldn't expect anybody to investigate that?
for sending an email to my personal lawyer relating to my report to law enforcement
Yeah.
and to be retaliated against by being placed on investigative leave. Is that...
No, my question was a little bit different, so let me be clear about what the question is. Wouldn't you expect the Office of the Attorney General to investigate your use of your office email to send secret grand jury subpoenas to that man, Johnny Sutton, and then delete the email? Wouldn't you expect to be investigated for that? Yes or no?
No, not necessarily.
Okay. Wouldn't you expect to be fired for that?
No.
Wouldn't you expect to be fired for reporting your boss to the FBI without any evidence?
No, I would expect an opportunity to answer questions based on answers that I was provided when I asked, what documents are you alleging that I disclosed? And when no response was given, I couldn't give any further information about who the messages may have gone to or for what purpose.
Mr. President, I'm conscious of the indulgence of the hour, and I want to make sure that I'm not running up against any type of deadline or keeping?
We were prepared to go to 7 if needed.
Would you like me to continue?
You may continue.
I will be happy to. You are the chief of the General Counsel Division at the Office of the Attorney General, correct?
At one point, yes, sir.
Yeah, so for the ladies and gentlemen of the jury who are here and may not be lawyers, and for the people of Texas who may be watching, you are really a lawyer to lawyers, correct?
That you could describe it like that. Yes,
That's
sir.
how I would describe it. General counsel is really a lawyer's lawyer, yes?
Yes, sir.
And so what happens in the Office of the Attorney General, when you are in the General Counsel's office, actual lawyers come to you and ask you for legal advice, yes?
Yes, sir.
And that happened regularly, true?
Yes.
You were first chief of the General Counsel Division, and then you were Deputy Attorney General for legal counsel, true?
That's right.
And your first involvement with anything related to this impeachment was being approached in the fall of 2019 with a question about an open records request made to the Texas State Securities Board, true?
That's true.
And Ryan Bangert approached you with a question. Remember, you're the lawyer's lawyer. He approached you with a question about whether the State Securities Board's involvement in a joint task force could harm the law enforcement or investigative privilege, true?
That's my recollection, yes, sir.
And you answered his question, yes?
Yes, sir.
And then you were not involved in anything else related to this impeachment matter until March 2020, true?
That's not true. I think it was May of 2020, which was the DPS request.
You're wrong about that, but
Okay.
I just want to make sure I understand what your understanding of the timeline is, okay? So when was the period of time when you believe you first got a request or an open records request related to this impeachment matter?
Well, to back up just a little bit, if I may, I was not promoted to deputy for legal counsel until April 1st of 2020, so I wouldn't have been overseeing the open records division until after April. So I don't know when the DPS request was submitted to our office. That could have been the date that we received it in March, but I wouldn't have been tasked with anything related to it until after I was promoted on April 1st, and then the conversations that I had in May of 2020.
Tell the ladies and gentlemen of the jury who Joe Larson is.
I believe he's an attorney representing Nate Paul.
And what type of work does he do, to the best of your understanding?
I'm not sure. He was a requester in 2 of the open records requests.
Yes.
I don't know if that's his practice.
In fact, Joe Larson works at, he's pretty well known in the state of Texas for being a Public Information Act lawyer, yes?
I'm not sure.
Had you ever encountered him before?
No, sir.
Okay. So I'm going to tell you, my understanding is on March 3 of 2020, Joe Larson sent what I call the big request to DPS. Okay, so the one that happened in 2019 was a request for public information was made to the Texas State Securities Board. Yes?
Yes.
Ken Paxton asked you about the law enforcement privilege. You answered his question. Oh, I'm sorry. Ryan Bangert asked you about the law enforcement privilege. You answered his question. And that went away. Poof. Yes?
Yeah, I never heard anything else. Yes, that's right.
Then March 3 of 2020, Joe Larson made a Public Information Act request to DPS, what I call the big request. He's asking for a whole lot of information related to the search warrant execution on Nate Paul. Yes?
I don't know about the dates. Again, I don't know when he submitted it to DPS, but yes, if that's how you want to categorize the big request, then yes, that is accurate.
Well, this is probably beneath many of the people on the jury who very well understand this, but for people who are watching at home, when someone makes a Public Information Act request of an agency in the state, the agency comes to the Office of Attorney General for representation, says, help us decide. Yes?
It's not representation, but it's a request for a ruling.
Yeah, they want a ruling.
Right.
And so in this situation, DPS wanted a ruling. Yes?
Correct. If they want to withhold anything under the Public Information Act, they must request a ruling.
But Joe Larson didn't wait for your ruling, did he?
I don't think I follow.
On April 10th of 2020, Joe Larson sent a demand to DPS saying, I asked for this stuff, give it to me now. Are you familiar with that request or demand?
No, sir.
And on April 16th, he filed a lawsuit to get it. Are you aware of that, sir?
I recall the lawsuit.
I'm going to show you what's been marked as Exhibit 5. And maybe light one copy. Your Honor, may I approach the witness? Thank you.
Thanks.
We move for admission of AG Exhibit 5.
Mr. Hardin?
No objection, Your Honor.
Mr.
AG
Arroyo.
Exhibit
Oh, I'm sorry.
050 should be admitted to evidence.
Thank you, Mr. Arroyo. Exhibit 5, if you would. This is good. What is this, Mr. Vassar?
This appears to be a petition for mandamus filed by Joseph Larson, as a plaintiff against the Department of Public Safety, April 16th of 2020.
Who did he sue?
He sued the department, it appears.
What did he sue to get?
I'm not sure.
Take a moment and look through it. Maybe you can figure it out.
Sure. So according to count one, Joseph
You don't need to read it out loud.
I'm not.
Okay.
I'm summarizing.
I'm sorry. Go ahead.
He's suing DPS because of his claimed refusal to produce the information that he requested.
Mr. Arroyo, can you find count 1 for the ladies and gentlemen of the jury so that they're not listening to this blind?
Do you want me to continue?
Not quite. There you go. Thank you. Can you just pull up count 1? Mr. Larson is suing DPS based on his big request for all the documents that DPS has related to the Nate Paul search warrant. True?
I don't know. It looks like, yes. Page 1 references the March 4th, 2020 DPS request for all communications. So we could call that one the big one, if that's the big request.
I call it the big request.
Okay.
Okay, so in the big request, Mr. Larson is suing to get all the raid information. Yes?
Yes, I mean,
Probable cause affidavit. Yes?
it says all communications in this document, but I would assume it would have said all records.
He wants the full Monty.
Right.
Everything DPS has related to the Nate Paul search warrant. Yes?
I'd presume
And
so.
he's suing to get it. Yes?
Yes, it appears so.
And the OAG was aware of this litigation. True?
Yes, we became aware of it. I don't recall when, but
It would be pretty stupid for Nate Paul to sue to get something that he already had, wouldn't it?
well, this predated any conversation. This lawsuit could have even predated a request for ruling to our office. So
Let me press pause there for a second. To be clear, this big request is the request to which OAG responded and said, we take no position on it. True?
yes, the big requests.
Yeah, the big request. So this thing, by the time OAG even decides anything, Joe Larson's already sued DPS to get it. True?
Correct. If I'm following, so this was filed, it appears to be April 16th. The OAG's non-decision in the big request was June 2nd. So this lawsuit, and I apologize if I'm not following you, but
You are following.
Okay.
Mr. Vasher, you are following me. What happened is Joe Larson says, I'm not going to wait to see what the OAG decides on this. I'm suing. Right?
sure, I don't know what he was thinking at the time, but
And the OAG's no decision on the big request did not lead to the production of any documents to Nate Paul, did it?
Not under the Public Information Act. No, sir.
No. But Joe Larson didn't stop there, did he?
If you're talking about the public information request to the Office of the Attorney General for the FBI brief, then you are correct. He did not stop there.
All right, let's press pause there. This third request from Joe Larson was for an unredacted copy of the FBI's brief. Let's go back a step. This is very confusing and arcane, so I want to go slowly, all right? When Joe Larson made the original big request of DPS for the search warrant, etc., DPS had to give notice to the FBI, yes?
Yes, sir.
Because they were holding the FBI's own documents, yes?
That's right.
Said, hey, we're holding some stuff that probably by right belongs to you. Do you want to object? And the FBI has a period of time to object, yes?
That's right.
And what the FBI did in response to that was they sent a legal brief, yes?
Yes, sir.
And that legal brief is a bunch of legal arguments from a lawyer at the FBI, yes?
That's right. The brief identifies the content of the information that the agency wants to withhold.
And the brief that the FBI generated and gave to Mr. Larson was almost completely redacted, like something you might get from the CIA, right?
I don't recall exactly, but based on what I recall, it was redacted.
It was just basically a bunch of pieces of paper with big black blocks on them, right?
I don't recall, but it was redacted. I do remember that.
And Joe Larson says, this is no good. He makes a demand for the unredacted FBI brief. He made a third request, so request number 3 under the Public Information Act, for an unredacted version of that brief. And he made it directly to the OAG's office, yes?
Yes, sir.
He didn't make it to DPS. He didn't make it to FBI. He made it to your office, yes?
Yes, sir.
And what happened is the OAG sent notice to the FBI, the same notice DPS had sent earlier, and said, hey, this guy wants a copy of the unredacted brief. You guys need to show up and object if you don't want him to get it. True?
Yes, that would have been the third-party notice.
And the FBI blew it, right?
I don't recall. I was not involved in those conversations. I don't recall what happened.
The FBI didn't respond in time. True? True?
I believe that could be true. I don't recall. I'm happy to refresh my recollection if you have.
Joe Larson got the unredacted FBI brief, yes?
Yes, I believe so.
And he got it because your office decided the FBI blew the deadline, yes?
That's functionally correct.
Functional? What do you mean? What does that mean?
Well, after we had advised General Paxton about the issue.
What did you need to advise him about? Ken Paxton, hold on a second. Ken Paxton.
Excuse me. He asked him, what do you mean? He's in the middle of answering, and he cuts him off because he doesn't want the answer.
Just stay.
Excuse me.
Slow down.
You're very right. My apologies.
Did you want me to?
Did you need Ken Paxton to tell you that the FBI blew the deadline?
I'm sorry. Did I need Ken Paxton to tell me that the FBI missed the deadline?
Yes.
No, sir. No. I brought it to General Paxton.
Not responsive to everything after no, sir.
Sustained.
So, after the FBI blew the deadline, Joe Larson got the unredacted FBI brief fair and square. Yes? Yes?
I assume so. I did not provide it to him, but I assume a copy was provided in response to the decision to let the brief go out.
Okay. Just make it like, tell the ladies and gentlemen of the jury like you would a 7th grader. Did Joe Larson get the unredacted FBI brief because the FBI blew the deadline?
It was mainly because General Paxton told us to release the FBI brief.
And he told you to do that because the FBI blew the deadline, right?
I don't know if that's why he told us that.
But they did blow the deadline, yes?
I don't recall. I was not involved in contacting them directly. I don't know what any responses we would have received or when.
Sorry. You're in charge of this, yes?
That's right.
And you can't remember, right?
No, I don't. I didn't have direct contact with the FBI about a brief or a notice. Those are all handled by the Opinions Division.
Are you satisfied in your own mind that the proper notice was provided to the FBI and the deadline was not satisfied?
Based on my knowledge, yes. I didn't see it, but
Nate Paul's lawyer got that fair and square, didn't he?
maybe under the Public Information Act,
The law, you mean?
correct, just under an interpretation of whether sufficient notice was provided or whether a third party submitted briefs that it wanted to submit.
It's just a brief. It's just a bunch of legal arguments, isn't it?
It is.
You told Rusty Hardin when he asked you on direct that this item contained all types of information that would subject law enforcement to potential retaliation, that somebody might come and shoot them at their home or something like that. That's not true.
Well, that's not exactly what I said.
This unredacted FBI brief is just a bunch of legal arguments from some Fed lawyer, isn't it? Isn't it?
The act requires the brief to identify information to which exceptions might apply.
That's all he asked for, right? The brief.
Correct.
So the insinuation that Ken Paxton somehow got the file and sneaky, delivered it to Nate Paul, you don't have any evidence to substantiate any of that, do you?
I have no direct knowledge of what he did with the file when it was in his possession.
You want to make an accusation while you're here on the stand? You want to accuse the elected Attorney General of this state of delivering something to Nate Paul that he shouldn't have? Do you want to do that now?
I don't know what he did.
So when Ken Paxton asked for the file, you gave him the file, right?
Yes, sir.
And he had every right to ask for that, yes?
Yes,
If he just felt like looking at it, he could ask for it, yes?
that's right.
And irregardless of his feelings about Nate Paul and whether he was unjustly being railroaded or the feds are mistreating him, he had every right to look at it, didn't he?
Yes, sir.
And you don't know that Ken Paxton did anything illicit with that file, do you?
No, sir, I don't.
You're not here to testify about any of that, are you?
No.
In fact, when Ken Paxton had this meeting with you about the file, he told you that he had spoken to Nate Paul. He didn't hide that, did he?
No, sir.
He told you he would believe that Nate Paul was being railroaded just like he has been, yes?
Yes, sir.
He told you he didn't trust DPS or the feds, didn't he?
Yes, sir.
And he didn't hide that, did he?
Not in that meeting.
Do you, by the way? Do you trust the feds? Trust the FBI?
Yes, I have no reason not to. I trust law enforcement and our peace officers.
You can't think of one reason in the last 3 or 4 years not to trust the FBI?
I'm speaking mainly personally.
Ken Paxton told you he didn't want to use his office to help the feds in any way, didn't he?
Yes, sir.
He didn't hide that from you, did he?
No, sir.
And when you were discussing the ruling, what I'll call the no decision ruling on the big request, you reached an impasse where each side made its case, and he's the boss, right? Yes?
Yes, sir.
And he didn't overwhelm you. He didn't tell you to do anything against your conscience, did he?
No, sir.
He told you to be a lawyer and make a decision, right?
No, sir.
You made a no decision, yeah?
Well, to clarify, it wasn't my decision to make. It was his decision for the ruling to be a non-decision. There was a couple of decisions in there that maybe confused me.
Have you ever seen the probable cause affidavit in connection with Nate Paul's search warrant? Have you seen it personally?
Yes, sir.
Earlier, you said that you delivered a file to, you gave a file to Drew Wicker. And just show the ladies and gentlemen of the jury with your fingers how thick that manila envelope was. Like that?
I'd say less than 1/4 of an inch, just not very thick.
Probable cause search warrant affidavit is 224 pages, isn't it?
I don't know.
You don't know? You said you saw it.
Well, I saw the body of the affidavit. I don't know if there was anything else attached to it. When DPS submitted its request to us, it was a request based on representative samples of information. So we would have received a representative sample of whatever DPS provided. And I don't recall seeing a document of that size.
Counselor, we'll go maybe 10 more minutes. You can stop anywhere you'd like in between.
You're very kind. Thank you. I want to talk about the foreclosure guidance for a few minutes before we retire for the evening. The legal question from Ryan Bangert was, are foreclosure sales gatherings, quote unquote, since the governor and the local county judges and mayors had prevented gatherings of 10 or more people, right?
Yes, that's what I remember his question to be.
That's really the simple legal question. And you, as a lawyer at the OAG's office, you do your research and then you take a position, yes?
That's right.
Okay. And we agree that what you were doing was not a formal attorney general opinion, true?
It was not formal. That's right.
These are what you call informal letters or announcements, yes?
Yes. Informal opinions. I mean,
Let's save us a little bit of time. I have a transcript of what you told the House Board of Managers. And what you told them was this AG foreclosure guidance was an informal letter or announcement. Yes? True?
if that's what you're saying,
Is that what you said?
I don't recall. Again, based on my recollection of 402 and 418, those are the only two statutes that give the Office of the Attorney General express statutory authority to issue legal opinions.
And after Austin Kinghorn did the research and he explained to you his position on it, you talked to Ryan Bangert, true?
Yes.
And Ryan Bangert called you and said, well, that's not the right answer, true?
We prepared a draft and then provided that to Ryan Bangert, and then, yes, he called me and said that's not the right answer.
And Ryan Bangert told you General Paxton wants to stop these foreclosure sales, right?
Yes, he said we reached the wrong answer.
Yes. And so what you know secondhand is Ken Paxton disagreed with the result that you and Austin came up with, didn't he?
Yes, that's what,
And he has the right to do that, doesn't he?
yes,
And he was elected to make those decisions, wasn't he?
yes.
Did Ryan Bangert tell you, you know what, Ryan Vassar? There's two Ryans. I'll sign this so you don't have to ruin your career, Ryan. Did he tell you that?
No, sir, I don't recall.
Did he intimate that?
No.
Did he imply it?
No, it was basically a timing.
What do you mean it was basically a timing? Tell me what you mean.
We prepared the first draft. By the time Ryan had finalized the second draft, it was 11 o'clock at night or midnight, and he was talking with General Paxton, is my understanding. So I had gone to bed and wasn't available to sign it.
Were you happy to sign it?
I would have signed it.
You didn't avoid signing it, right?
No.
You didn't say, Ryan, I don't feel comfortable. Would you sign this instead of me?
No, sir. I didn't say that.
So Ryan Bangert didn't jump on the grenade, so to speak, and say, you know what, this is really dangerous, Ryan Vassar. I'm going to sign it. Did he?
Not that I remember.
Did Ryan Bangert tell you, Ryan, I totally disagree with what we're doing here, but I'm going to do it over my own strenuous objections?
I don't remember him saying that.
You worked on this opinion on Saturday night, right?
It was all day Saturday. Yes, sir.
But that wasn't even the only COVID opinion that went out that day, that Saturday, was it?
I'm not sure. I would have to go back and look.
Well, I'll put it in front of you here in a little bit. You do not have the first clue whether this informal foreclosure guidance stopped a single property foreclosure, do you?
I have no direct knowledge.
And you heard it secondhand from some Austin Business Journal article, right?
That's right.
Did you believe it? Did you believe it?
I had no reason to disbelieve it just based on the timing.
Did you do any research yourself?
No, sir.
Any investigation at all?
No, sir.
Just one problem. It's 100% false. Never happened. It's not true. It's pure fiction. Did you know that?
And no, I wouldn't have had any reason to know that.
Your Honor, I believe this is a good time to stop for tomorrow if Your Honor is willing to conclude for the day.
Yes, court will adjourn for the day, 9 a.m. tomorrow morning.